Okay, good morning to everybody here, and thank you for coming to the Education Funding Committee that we have. We have several bills coming up today, three of which for the higher education are HB 443, 510, and 112. On this subcommittee, which we have for these bills, we have members, and I'll just go around the table here. Representative Peoples is on this subcommittee. Representative Popovich is on this committee as well. Representative Brown, myself, to my left, Representative Bricky, Representative Burton, and Representative Damon. Let's see. No, wait a minute. Excuse me.
And
Yeah.
Representative Peoples is not either.
Peoples is not.
On the higher education, we have Representative Luno and Representative Burton. And Representative Peoples is not on this. He's on the school building aid. Excuse me.
The 1 p.m.
Okay. So what we have too is we have some substitutes on this committee now, and we'll have them periodically. Representative Luno is unable to attend due to some family matters going on. And so he has been replaced on this committee by Representative Bricky. And we all wish Representative Luno well with his endeavor he has in front of him. And so with that, now we may have other representatives are on the full committee. They're always welcome to sit up at the tables. They will not be taking, they can have some discussion, input, but they won't have any, participation in the final vote of the subcommittee. So the first one we're going to start out with is what I consider our easiest bill. That's HB 443. This is bill relative to the terms of appointment members on the Higher Education Commission. As you recall, we had this discussion when the bill was presented, and the bill had several sponsors, Representative Cordelli and Senator Waters, so it's a bipartisan bill. It's a bill which was looking at changing and giving the authority to replace members on that commission if they're not attending or if they're no longer representing the organization which they've been appointed for, and they haven't been attending. This was the position of the previous governor, and I talked with Mr. Appleby over at DOE on this several days ago, and again driving down the highway this morning for about 20-30 minutes. The previous governor felt it was necessary to have this so that we could replace people on the commission who were not attending and who basically weren't representing the organizations in which they were intended to represent. The new governor's position on this is that this bill is not needed from the rationale that if you're not attending and if you're no longer representing that organization that you are appointed from or for, then you basically have resigned or you're no longer a member. So they feel that this time the governor's office is saying, we don't need this bill. So I'll start off with that and I'll open it up now to discussion on the part of those on the subcommittee. Anybody else? Representative Popovich?
Thank you, Mr. Chair. Just a question. Obviously, I'm not a lawyer. Do we have an opinion on which of those stances is valid? Because I'm concerned that if we don't give the governor the authority to call, lack of attendance a resignation, there could be legal challenges and so on and so forth. So, do we have any legal opinion? Do we have any, position one way or the other on that legal question?
I don't have it myself, no, but I do know that when the governor's taking the position, the governor doesn't operate in isolation. She will also use her legal advice. Representative Fellows.
Yeah, my thought is kind of along that same line. And if the governor has the authority to replace a person who doesn't show up, then why is it only for this board and wouldn't it apply to any kind of board appointment?
Okay. We have an attorney with us from the university system. Do you care to, Tom?
outside my area of expertise.
Yeah, yeah. Okay, is there any further discussion on this bill? We're not going to take any actions today, but I think that this bill being what it is, it's in terms of some of the issues which we're tackling right here now. Does everybody know the purpose of this commission and all? Yeah, yeah. We have had that discussion. So if there's not any further discussion on it, I can say right where I am right now, I'm leaning on saying that the bill is not needed. That's my position. We will, of course, allow caucuses to occur, and we'll come back at the next time we do meet, we'll be addressing this so we can have a recommendation to go forward. The recommendations that we're going to be making, the final ones as a subcommittee, will be most likely during that first week of November. So we will have the opportunity to, if we can't come to agreement on something, and if we see there's some reasoning for, we'll have another week in which we could make an amendment. But we won't be really dealing with this issue again until we perhaps have to meet for the other higher education issues and then address 443 at that time. Any further discussion on that one? The next one I'd like to deal with is seeing that we have folks here from the university system is, both of these are relevant to that and the community college system. Let's take up HB 510. That's relative to establishing certain due process rights for students, student organizations, faculty members facing disciplinary actions by state institutions of higher learning. Okay, and I'll read the analysis on the bill. This bill establishes for students, student organizations, faculty members of publicly funded New Hampshire colleges and universities the right to certain due process protections when disciplinary proceedings are brought against them by such institutions, and addresses the provisions applicability to collective bargaining agreements. We've had this bill or similar bills coming to us in the last several years. And there's been always a number of reasons why we wanted to have more discussion or study or communication with the university and community college systems. And so I will open this up to discussion on the part of the subcommittee at this time. Yes, Representative Burton.
When we took this bill up last spring, I took the time to go through all of the regulations at the campuses. This file is all due process. Just about everything you can think of is in here. And I knew this because I was an assistant dean at UNH and responsible for these processes for a while. I don't think this bill is needed. I think it would interfere with collective bargaining. I think it would interfere with the university and their campuses dealing with situations that are unique to them. But this bill would apparently replace all of these that were actually developed campus by campus through their governance processes. And I don't think it's needed. I understand the sponsor's concern, but the passage of this bill would negate all of this work that's been done and is working on the campuses in our state. Thank you.
Representative Popovich, then Representative Bricky.
Thank you, Mr. Chair. As a co-sponsor of this bill, I think you already know what my position on the bill is. And I just want to quickly point out that my colleague did a lot of work to read a massive amount of regulations. And I think that stack of papers is about 150 pages tall, right? What odds do you think, the kid has to understand those regulations and navigate them? At the end of the day, the intent of this bill is to ensure that certain rights are protected for all our students, which I want to remind you, they are legal adults, so they should have full rights. And I really rarely heard of a particular right that people feel should not be protected here. I think that if anything, the arguments against this bill are that, oh geez, the bill is unnecessary because we absolutely do all this. In which case, if we already do all this and protect all these rights, well, the bill shouldn't make a difference. The more we argue that the bill is a burden, the more we are arguing that those rights are not currently being protected and it would be a burden to protect them. So I don't want to get into a humongous, depth level here, even though I would welcome anybody who wants to. But in a nutshell, that's where I'm coming from. I think it's important to respect everybody's rights. I think this bill would, make our campuses better in every way, and I continue to support it. Thank you.
Representative Bricky.
So I guess, getting back to what Representative Burton said, it seems to be working on the campuses. I don't believe that we've had any complaints, I have no idea why it was brought forward in terms of, it seems like it's a solution to a problem that's not really happening anywhere on any of our campuses. Do I want to argue against due process? No, I don't want to argue against due process. But as Representative Burton said, it seems to be taking place on all the campuses already. We're not getting complaints that any campus has been, having issues with it. And I believe that all the rights have been protected and are being protected of our students, our faculty. And I think that this is a bill that, like I said, it's a bill that's a solution waiting for a problem. And I think that we don't need to have any more problems. Also, I'm wondering, no, that's it.
Representative Brown.
So I've reread some of the campus regulations at UNH, academic catalog, and it does have a section for students, right to due process, already a part of the Student Rights and Responsibilities Handbook. It indicates students have the right to be informed and have access to university policies. When students are accused of engaging in prohibited or academic behavior or conduct, they have a right to a fair disciplinary resolution process. Timely notice, an opportunity to respond. They have the right to have their case adjudicated by an impartial fact-finding body and to challenge fact finders. So they do indicate that students have due process rights. However, this bill actually does flesh out some of the specifics. How many days are required for the rights for the complaint to be presented and for the evidence to be provided to the student or the staff faculty member. And those details are something that any labor union would insist on being included when it comes to processing complaints. So I actually support this bill strongly. I'm also concerned that the grievance procedures at UNH direct students with a complaint to various faculty, department heads, administrators, but there are no independent ombudsmen on our campuses that I could find that are specified to provide the student with some representation when there is a complaint. However, when it comes to a labor union complaint or grievance, the union pays for representation. Students have no such staffer available to them that's an independent voice for them. So that is something I think should be amended to the bill.
Okay, I'd like to, I'm not going to go in that direction right now. We will get there. But where I see my concerns are with the bill. In the previous year, we had a bill come forward to us. That was HB 1305. And that dealt with relative freedom of speech and association at public institutions of higher education. That is in chapter 188J. We are talking about a new chapter, 188K. I'm going to hand out a sheet to everybody here on the committee. When I went back and looked at the definitions which we have in here,
Did you want? Okay.
if you look in chapter 188J, and then you look at J:1, it lists definitions. And I'd like then for you on the committee right now to look at the definition for these that are in 510, which would be the new definitions for K. The first definition look at, please, is the definition for public institution of higher education. In J, the definition reads, means any public technical institute, public junior college, public senior college or university, law school, medical or dental school, public state college, or other agency of higher education as defined in state law. In the new definition, it reads, public institution of higher education means a post-secondary institution of higher education publicly funded by state of New Hampshire, including all component colleges and universities of the University System of New Hampshire and all component colleges of the New Hampshire Community College System. Two different definitions. Now let's look at the next definition as well. Let's look at student. The definition in 510 is student means a person who is enrolled either full or part-time in a course of study at a public institution of higher education. As we have in law right now, the definition of student means any person who is enrolled on a full-time or part-time basis in a public institution of higher education. A little bit different. And let's look at the last one, student organization. In law, we have right now a student organization means an officially recognized group at a public institution of higher education or a group seeking official recognition comprised of admitted students that receive or are seeking to receive benefits through the public institution of higher education. And here we have in 510 a different definition, means an organization or group of students who share similar interests or activities and which is recognized and approved by or has sought recognition or approval from a public institution of higher education. I realize these are different chapters of law, Chapter 188J and Chapter 188K. So a case could be made to have them different. My concerns are that after working with attorney here in the House, it's going to create confusion. And so in one of these definitions, three of the definitions were written in the previous session, and they became effective, if you look at the effective date, August 1, 2025, not too long ago. Now you have this new definition coming in, which is somewhat different, but was perhaps written without the knowledge of what we have here. My question to the subcommittee, should we try to align these definitions? Representative Popovich.
Would I be able to hear the opinion of the prime sponsor who's in the
Yes,
room
we
on
can.
this topic?
Yes, we certainly can. If Representative Lynn is wanting to sit in that big chair.
Well, thank you. As I listen to, I have this bill in front of me. I don't have the bill that,
Is there, we have another copy which would.
yeah, no, but I mean, I know I was paying attention as you were reading off the definitions, and it seemed to me, I mean, there's no question that is different language used in the two. Yes, that's true. There is different language. I would tend to say at least the only one where I thought there might be some substantive difference in meaning was in the term student organization between the two. But I guess my suggestion would be, I think you raise a valid point of not, it doesn't make sense to use different words in statutes that are at least similar. So, I mean, my suggestion would be, since the other chapter is already law, why not just substitute the definitions here and take the ones that are in 510 out and substitute the definitions from the other, so that there is no difference. As I say, I think there might be a slight substantive difference between the meaning of student organization in section 188J and what is proposed here. I'm not sure it's all that significant a difference, but why, I mean, I agree with you. Why even create the possibility of confusion? Why not just substitute the same definitions that are already in law? That would be my suggestion.
Representative Lynn, thank you. That's basically what I was going towards. When even looking at the definition of student, which is very similar, but one is saying enrolled in a course of study, one doesn't have course of study in it. You can be there as a student getting a certificate in something. Is that a course of study? Or you could be there getting a badge of some kind. Is that a course of study? I don't want to go down that rabbit hole and start having to defend what a course is, what a course is not. Is it for credit? Some courses are not for credit. So I was just trying to, when I looked at this and looked at the old bill, I saw this difference in the three areas, and I thought maybe we should be aligning these.
Sure. I think that makes sense.
Representative Popovich.
Thank you, Mr. Chair, and thank you, Representative Lynn, for being here and talking to us. I obviously would be perfectly happy to amend as needed, but then we'd have two parallel definitions in two chapters that are identical to the other, and I'm wondering if that wouldn't create a bit of a maintenance issue if at some point in the future one of them gets amended. Would it be acceptable, and I don't know enough law to answer this, to just say as defined in Chapter J? So instead of
There's a lot of ways to it. You could say wherever you have the word student pursuant to, or say whatever it is.
Honestly,
J.
I would rather lean into having the definition in one place and refer to it than having 3 copies of it all over the place and then losing track of where we define stuff, because we know how big these statutes can get. And these are neighboring chapters, but that was the only other thing I wanted to add. Thank you.
Yeah, I think that's important. We have a lot of definitions in education where a public school, is that also an independent school? Is that an academy? Is this, that, or that? It's wise to get a solid definition so there's no confusion. So I think this can be worked out. We could do it in conjunction with the prime sponsor of the bill. We could do it in conjunction ourselves here. I think that's not a very difficult thing to achieve. Is there, Representative Burton?
Thank you, Mr. Chairman. The Trump administration has threatened to cut off all public funds to universities that don't do away with DEI. Would this bill allow students to appeal that decision?
I think I don't, to appeal that, I think this really deals with disciplinary action. So unless, if somehow that controversy got into resulting in a student or a faculty member being faced with disciplinary action, I suppose they could challenge that, but I don't think that this addresses the issue of, DEI per se. In other words, I don't think this would give anybody a basis to just challenge a DEI provision or a lack of provision.
Mr. Chairman?
Yes.
In court 3 weeks ago, Judge McCafferty brought up the example of a faculty member, a very popular faculty member, losing her job because she was in the DEI area. You don't think students have an interest in that situation?
No, I'm not saying that at all. All I'm saying is I think that this bill, if it were to become law, would only be triggered if somebody were facing discipline. So I suppose, for example, what you just said, if a faculty member was going to be disciplined for taking some action, teaching something that somebody thought was prohibited DEI or whatever, sure, I think they would have the right to invoke their rights under this provision. But if there was no, all I was saying is if there was no disciplinary action brought, then this wouldn't come into effect.
So in follow-up to this discussion, I don't know how many people read the Wall Street Journal, but just yesterday, there was such an issue at Texas A&M, and the president of Texas A&M was forced to resign over this very issue. So it is a live issue within our higher education, institutions today. I think irregardless whether you have this bill or not, current language would allow that trigger to occur that we have in law. So I just give that information out to you all. It's maybe you want to look at what happened to A&M. Further discussion on this one. Yes, Representative Bricky.
So I still want to go back to, so are you saying that nobody has the right to due process now, and that's why we need this bill?
No, I'm not saying,
Then why do we need this bill?
I-
If
well, I
we already
think-
have the right to due process, why do we need this bill?
I guess what I would say is, when you say you have the right to due process, there's no doubt in my mind that there are procedures in place in the university system that afford some level of due process. I'm not sure that they afford the same level of due process that is provided in this bill. I guess I have to sort of follow up on what Representative Papavici-Muller said. I think that there's at least a question of whether they do, number one. And number two, Representative Burton referred to a fairly thick bunch of documents of, several hundred pages. This bill is 3 pages long or 2.5 pages long, and establishes, I think, sets out, I think, relatively clearly what due process rights are to exist. It seems to me that's a lot. If it really takes several hundred pages to spell it out in various, regulations that the university has, this seems to me to be a lot simpler. I think it also, the one area where it comes to mind, particularly from prior hearings we've had on this bill, both last year and 2 years ago when it actually passed the House, is the issue of the right to confront witnesses, particularly in where a student is facing an allegation of some kind of sexual assault, something like that. The ability of the student to face the person that's making the accusation. That was a particular area of concern. And I think this kind of spells that out, and I think is particularly important that right be afforded.
Can I follow up?
Follow.
So do you believe that students in all the institutes of higher ed would have read the bill as opposed to their student handbook?
I guess what I'm saying is, if it really takes all that paper to spell out what's in the student handbooks, I think it would be far more likely that students would be able to read a 2.5-page law than they would to go through.
But my question is, sorry.
Go ahead.
Nope, that's all right.
Okay, Representative Popovich, you had your hand up?
Thank you. I was happy to yield to Representative Damon, but it's a very quick point I want to make. One of the statements that was made about the thick book of regulations was that that was developed specifically for each campus, which to me indicates that different campuses and different organizations have different standards and different regulations that were adopted for that campus. I think as a state, we should give everybody equal protection and make sure that certain standards are applicable to every campus. And this, to me, sets the minimum amount of protections that everybody should have when they attend a higher education institution. So, thank you.
Representative Burton.
Representative Pavlovich, I agree with you for once. I agree with you for once. This is UNH, Sten, Plymouth, Sten, Keene State, Sten. They're all different because they reflect the cultures of those campuses. Keene State, Plymouth were teachers' colleges, and they developed their own. But the themes are the same. They guarantee student rights. They have a chance to make their case. They go before a peer group, and a decision is made. This is not the thick bundle I said was the. And that doesn't include the community colleges. They are not. They're larger. You see what I mean? These are not. I just held up all of them at once. Okay. And I think, having worked in that system, if anything, we were accused of overprotecting student rights, which I thought was fine. When I think I deemed that a compliment. I just don't think that, leave it to the colleges to govern themselves. They do a great job. There's no indications that the rights of students aren't being met, or parents within the law. I don't think the state needs to chime in from this level and throw out collective bargaining units that already been settled, that already have clauses in them about due process. I don't think it's needed. And I'm not sure what's causing this to come to us. Thank you.
Well, just if I could just briefly respond. One of my understanding that when this bill or something very similar to it passed the House, I believe not last year, but the year before, and it went to the Senate and died in the Senate. My understanding was that the reason that the main concern of the Senate was that it would interfere with existing collective bargaining agreements. And so that's why, that would seem to me to be a legitimate concern. I guess I had some question as to whether it really would, but assuming that the Senate thought that it would, that's why I drafted this bill to say, look, if this bill passes and there are existing collective bargaining agreements, this bill does not apply until those collective bargaining agreements end. And once they end, then it basically says that no union and school can enter into a new collective bargaining agreement that provides less protection than the statute would provide. And it seemed to me that's they can still enter into, collective bargaining agreements in dealing with faculty rights, but they have to ensure that they have at least the minimum protections that are in the bill. That seemed to me to be a reasonable solution to the issue.
One more, Representative Burton and Representative Damon.
You just admitted that this bill would interfere with the collective bargaining process. When one contract ends, they negotiate another one. They shouldn't have the state at the table telling them what they can negotiate and what they can't.
Representative Burton, I don't think that's what Representative Lynn implied at all. I think he was saying when the negotiated agreement terminates, then the next agreement can't be any less than what the state law is.
And that's the state telling them what to bargain for. And that would hurt collective bargaining.
Well, but if that's true, the state law also says that you can't discriminate on the basis of race, sex, or other things. And I suppose from that perspective, that interferes with collective bargaining agreements too. They can't make a collective bargaining agreement that says you can treat, African Americans or Jewish people or whatever differently than anyone else. I tend to think that it's a good thing that the state law says that.
Representative Damon?
Thank you, Mr. Chair. Different concern than what has been stated so far. I think it is risking grave harm to victims of sexual assault to be cross-examined by their assaulter. We talked a good deal about this in the prior committee hearing on this bill and in past years. It is beyond inappropriate to expect that should happen. The existing due process procedures on campuses allow the entities that will make the decisions about whether someone is, what's the word I'm looking for here? Whether they are guilty and what the consequences would be. They can certainly hear from all the witnesses, all the people involved, but to ask the victim to be cross-examined by their assailant would be an unconscionable harm.
I guess I have.
Go ahead.
Yeah, I'm just going to say I have respectfully, Representative. I just have to. I fundamentally disagree with that view. The idea that somebody can be charged with something that will affect, even if it's not. I understand we're not talking about a criminal prosecution, but something that could affect the person for the rest of their lives. That they do not have the right to confront their accuser. And of course, let me make it very clear. The proceeding, that doesn't mean that anything goes, that the person that's accused can, berate, harass, yell at, whatever. Of course they can't do that. But that they have no opportunity to confront the person that is accusing them of something that could, adversely affect them for the rest of their lives, that's just not our system. That's why we have a presumption of innocence in this system. I guess that applies in criminal cases, but if somebody accuses you of doing something wrong, it seems to me it is a fundamental principle that you have the right to confront the person saying that. Of course, limitations can be placed on that. I have no problem with that. But to say that it doesn't exist, I just have to fundamentally disagree with you. I think that's a foundational principle of our society.
Representative Popovich.
Thank you, Mr. Chair. First, I want to point out that my colleague twice said that the right of the accuser to be, cross-examined by their assailant. I think what we should have said was the alleged assailant. Okay, because the whole point of those proceedings is that we cannot presume that one party always tells the truth and one party is always wrong. This is not how, society should work. I want to point out that we could quote specific cases in the past, not from New Hampshire, but nationally, where false accusations were made. And, I understand there is trauma involved. I understand that this is never an easy decision, and this is not something we should just, not be concerned with. But we have to balance the rights of the, victim and the rights of the alleged, perpetrator. The other thing that I would like to say is that the point was made that those are not always, they are not criminal investigations in nature. I want to say that I will question why an accusation of sexual assault is not treated as a criminal proceeding, because if rape happens in college, Jesus Christ, that does not mean it's not rape and somebody shouldn't go to jail over it. So to me, I don't draw such a fine line between the two, even though legally we could, because to me they are both extremely serious cases. And frankly, as I said, I think that if such things happen, they should be investigated and prosecuted according to the law, because those are terrible things and terrible crimes, and we shouldn't, slap people on the wrist anyway.
Thank you, Representative Pop. And I would caution you in not using certain reference to a religious individual. I hope you understand what I was. Okay.
Just did, and I apologize.
Okay. Going on, I'd like, Representative Lynn, I would like to ask at this time, the university's community college systems question, because there is an issue which has been bothering me, and perhaps the nature of this committee being education funding, I'm concerned with the fiscal note that was in the bill itself, where there's a cost on the part of the community college system of $100,000 per year and $500,000 by the university system in New Hampshire for per year. Can you explain to me why there are these additional costs when we already have attorneys at the university system and community college system?
We all just played a game of eye tag back there, and I think I lost. So I will try to answer the question. I think there are three sources of costs, and I'll say that this is a challenging fiscal note to write. So I'm going to speak to cost more broadly, and then we can try to go back to dollars at the end. I think there are at least three areas where there would be additional cost. One is because we do have different campus-created processes for students, staff, and faculty, each of the campuses, and we do have collective bargaining agreements. There would be an upfront, one-time cost, mostly in time, not money, of reviewing all of our current procedures, bringing it into compliance, sitting down with all of our labor partners, making sure that they understand and hopefully accept our interpretation of how the law interacts with the collective bargaining agreements. And that would be time more than money. But
Time is money.
And particularly, it's not a secret that the university system is going through layoffs. There is less person power available to do any task, and you're looking at diverting people from doing other things that are potentially more student facing. Second category, and this is where there is a bit of a difference, where I think the bill would potentially significantly change how we do things, and it's faculty discipline. Right now, faculty discipline, there's a raft of protections built into it through the contracts, but fundamentally, the faculty, through their choice, through their bargaining, have said that they want to have a role, a shared governance role in faculty discipline. So the hearing that takes place when a faculty member is under termination or suspension is before a jury of their peers. It's before a committee of the faculty senate. And it is specifically not an adversarial process because it's supposed to be consultative. It's supposed to be the faculty sort of, taking care of its own yard as part of its role in shared governance. And then that feedback gets given to the administration to make a decision about whether to terminate. And if the union thinks that we misstepped, they can grieve that, and that's what goes all the way through a full multi-day arbitration. If you plop an additional adversarial hearing on top of that, because nothing in here would remove that consultative process that exists now, you'd just be adding an entire other adversarial hearing on top of what's there. And that would be a significant additional cost in money if we went forward with those. The alternative is that there'd be a cost, but not in money, of this is just too hard now, and it's too expensive, and the administration would be less likely to move forward with to address faculty misbehavior or poor performance, because the cost in time and money would just be too high, and that has a cost to the organization too. If it's not in money, it's in efficiency and effectiveness. And then the last part is student organizations. Right now, the bill provides that if any student organization is to have any right or privilege taken away from it, we need to have a hearing that follows through all those 10 steps. I think I've mentioned this before, but rights and privileges include things like the ability to reserve space in the student union. So if a student club reserves space in a student union, they leave it a mess. And ordinarily, we just call them in and say, hey, you're not allowed to reserve space in the student union for a month because of what you did. We've deprived them of a right and privilege there, though. So under this bill, if it would become law in its current form, we'd have to go through that entire process, which again would either necessitate a really severe uptake in the number of trained folks we would need to go through this process on the student organization side, or again, we just do a worse job of managing student organizations, and that also comes with a cost. So if we continue to manage the organization in the way that we do now, in the way that we think is the best for students and faculty and for efficiency, then yes, you're looking at that sort of fiscal note. But given the financial realities the system is facing right now, there's also a chance that the cost is in person power, diversion of effort from other areas that might be more important, and just being less efficient and less effective. There's an increased cost one way or the other, and the system does question whether the marginal increased benefit that would come with this justifies those costs. I hope that's something of an answer.
This left me a little bit confused here in terms of at what point does an act that's been committed at a institution within university system become an issue which must be resolved by the court system versus the university senate or the college senate, faculty senate?
It typically runs in parallel process. So if there was something that could also be a criminal violation, the university, we cooperate with law enforcement, obviously, but those decisions aren't driven by us. So the police would do an investigation, the county attorney would decide whether and how and on what timeline to move forward. It tends to be a slow timeline, and so we typically move on with our procedures in parallel because it is a different consequence. One is about whether you go to jail, and another is whether you get suspended or expelled from school. And those are different consequences with different standards and different procedures. So the question of whether or not the criminal justice system gets involved is made by the criminal justice system, and the university doesn't really get involved in that.
Are there questions of the university system here from the committee regarding the costs? Representative Fellows?
Yes, I'm just in my mind thinking of like what are some, I live right next to Plymouth, and I grew up in Plymouth, so I'm, familiar with the college environment, that most of the situations that come up are probably about the student organizations, particularly the off-campus ones, and that a lot of what happens is really not criminal in nature, but the students that we're dealing with are just a couple of years out of high school, and sometimes their judgment is not very good. So that to go through this long procedure with, having representation and, who you get to question and all this kind of thing is really overkill for most of the situations that come up.
Yeah, I would say that from speaking to the folks who do this work, that our overall approach right now to student organizations in particular is much more counseling and advising than punishing where we can. But with the bar being so low for when it has to tick over into formal process here, it would be harder to keep managing it that way.
Representative Popovich.
Thank you, Mr. Chair, and thank you for being here and, spending the time with us and informing us. I wasn't sure when reading the fiscal note and hearing your comments, whether the fiscal note implies that additional hearings would be needed or whether we are just talking about the different requirements to prepare for and run a hearing. If you could clarify that, I would really appreciate it.
Yes, in those two areas, in the two areas I mentioned, faculty discipline and student organization discipline, additional hearings would be required.
Yes.
Just, I'm not sure which part of the legal language establishes that. Would you be able to point that to me? Because all I see in the bill, and again, it's been a while since I worked on it, all I see in the bill is rules on how the hearing should be run. I don't see the right to a hearing. I just see that if there is a hearing, you have the right to get written notice and so on and so forth. So, and if you want to follow up with that later, that's perfectly fine. I would just love to hear your opinion before I start voting.
I can give you my first pass at it, which is in 188K3, which is on page 2, Roman 2 at the bottom. It says the procedural rights, including the hearing specified in paragraph 1, shall be afforded to a student organization, or faculty member prior to the imposition of any discipline. Now, there's a carve out if there's a threat to safety. But in the absence of that, you have to do that hearing in those circumstances per the bill, per that section. That's my reading of it, at least.
Representative Damon.
Thank you, and thank you for helping us. Is it correct, I think I'm concluding from your remarks, that in the existing process on campuses, it's quite a learning opportunity for, I'm talking with students now, not faculty. It's quite a learning process for the students, and that the universities and the colleges endeavor for that, in fact, to be an opportunity for them to learn from the experiences that have occurred.
I mean, we're a learning institution, so we try to start there in general, I think is a fair thing to say.
May I continue? Mm-hmm. Do you see a difference in how that would likely play out if this bill were put in process?
With regards to student organizations, yes, because again, this would be a drastically more formal process than we use now. On the faculty side, shared governance is such a unique thing to higher education. But I do think there would be some additional disruption to switching to this formal adversarial, hearing prior to faculty discipline rather than the consultative process we have now. I don't work with faculty directly that often, though, so I don't want to go too far out on a limb on that piece.
Mr. Chair, I have one more, if I may.
No, I've got. Why are you calling it adversarial process?
This is everything that you would see for, some parts of this are imported directly over from criminal proceedings, which are as adversarial as you can get. But everything that's in here is what you would do if you're going to have at least a civil and sometimes up to a criminal trial. And those are by definition adversarial proceedings.
Representative Popovich.
I'm asking because I was going to bring the same point, and the chairman used his privileges to. I agree that those are protections that you would see in adversarial hearings, right? But is it your opinion that those protections cannot be provided in a collegial cooperative environment? I'm just trying to understand where you think this turns proceedings into adversarial. I do agree with your contention that this is the type of stuff you definitely must have in an adversarial proceeding. I just don't see where the culture changes because of this.
Do you know what? That's fair. I mean, I do think there are some, and one is what Representative Damon brought up about the confrontation of witnesses that I think has an adversary. And we're talking about cross-examination. That is a feature of an adversarial process. Perhaps for a lot of the rest of it, better, particularly with regards to the student organizations and the faculty, is formal or technical. You may want to substitute that in, and it would cover the idea more aptly.
Any further discussion on this bill or directing to the university system? Yes, Representative Damon.
Thank you. Just one more. Could you comment about what you would expect in terms of the need for students to employ lawyers to help them through this process, as opposed to whether there's any utilization of students having a legal advocate in the existing process?
The decision of whether or not to seek legal counsel by an individual student is right now very dependent on sort of the individual student and how they want to approach the process. I don't know that this would change that too dramatically one way or the other. We see some students who show up and manage it themselves. We see some students with some very anxious and involved parents who show up as their advisors, and we see some folks who seek legal counsel. And I think all of those options would still be available under this. I don't know how students would choose.
It was a number of years ago that Representative Pantelakis, she's no longer with us in the House, and I were working on issues at a private college within this state. And the lack of communication that was occurring at that time with the municipal authorities and the municipal system. I'm concerned that the process that we have in place, had in place there, was that without the communication directly with the municipality and with the chief of police in that particular community, there were a lot of issues which were being swept under the carpet and not being dealt with. Would this process then really try to slow that, I'm not saying that system, that was college in a private sister situation. This is not. In putting this into effect here, what's in here, the rights, the process and the procedural rights, would it then tighten up to protect our students more so than what we have right now?
I'll maybe try to divide into two pieces on the answer. The first is, I'll use UNH as an example. We have our chief as a sworn officer. He's sworn by the chief of the Durham Police. All of our UNH sworn officers are sworn in by the chief of the Durham PD. The communication's good. So I don't think that gap is there, because the relationship between campus law enforcement and the law enforcement in the various communities is much more aligned than it can be in private colleges, where you see the town gown thing be a little bit more. So I don't think that problem exists at the university system. As far as more protections, as I understand your question, it is focused on making sure that, again, things aren't swept under the rug in terms of making sure that complainants, alleged victims, get their due. I don't think this bill speaks too much to alleged victims' rights at all. It's about the rights of alleged, of let's call them respondents. That seems to be, I don't have to qualify that. It's about the rights of respondents. And that's important too. It's not to denigrate that, but I don't think it goes to the issue you've raised.
And going back to my first question, dealing with the dollars and cents here, $500,000, $500,000, is that an accurate figure, or is that something we just, out of the sky and say, well?
That was the best estimate we got from the folks who do the work back during the last session. I'll say this, when on those occasions when we do have faculty termination hearings go all the way through to arbitration, that can easily be one case can easily be high five figures to low six figures by the time you put all in costs for lawyers, the arbitrator, transcripts, everything else. I'm not saying that these hearings would be quite that expensive because I don't know that they need to be multi-day, but it doesn't take that many to add up to a big figure.
So when I look at the university system now, and I'm looking at Keene, Plymouth, UNH, Manchester, Concord, which are part of UNH, how many attorneys do we have hired within the system?
We have 4.
That's the university system, or is that UNH?
That's the university system as a whole.
For it?
For all the entities you mentioned, yes.
And are they located in all the primary campuses? Is one located on every primary campus?
No, we're a shared service, so we're in the system office in Concord.
Okay, thank you. Further questions from the committee, Representative Burton? Is that directed towards the university or not, or is it just amongst ourselves?
It's directed towards the university, Mr. Chairman.
Okay.
2 years ago, there was an unfortunate incident at the UNH campus when students protested the violence in the Middle East. Several students were arrested. The state police came with AR-15s, and their fate was handed over to the courts. And some of the students were found innocent, as I recall. And one of the leaders lost his attempt to be in the Peace Corps because he was held so long. There are incidents at UNH and I'm on the Durham Town Council. I'm intimately knowledgeable of what happened that day. I've seen it. There are instances where UNH does turn over student justice to the courts. Is that correct?
Where there's a potential criminal issue, it turns it over 100% of the time. I don't believe that any of the students you're talking about faced conduct repercussions, which is what this would be about.
Thank you.
Thank you very much. Any further questions of the university system? Thank you very much.
Thank you.
The community college system didn't speak in behalf of their money of the $100,000. Would you please do that, Shannon?
Good morning. Shannon Reed with the Community College System of New Hampshire. I would say I generally agree with what the previous speaker said about the impact of this bill on our current practices. One point I want to make, a couple points I'd like to make, and then I'll address costs. House Bill 510 is generally duplicative of current practices in that it includes protections of due process, but it includes specificity such that it would necessitate a significant level of work to basically redraw how we do things without, I think, substantively strengthening due process. We feel that due process is already well represented within all of our policies. As you may have noticed from what we submitted in the spring, we have several steps and phases to our procedures: informal resolution, step 1, 2, 3, arbitration, and rights are present in each of those phases. Representative Vlad mentioned other areas of law where definitions are different or conflict, and to that list that the chairman noted, I would add a couple of things. RSA 188H was passed in 2020. That's entitled Sexual Misconduct at Institutions of Higher Education. That's a fairly voluminous set of provisions that include its own sets of definitions and procedures and requirements. So I think it would be a responsible step to look at that alongside what's in House Bill 510. And some of the conversation between the sponsor and the members of the committee also implicates Title IX, federal Title IX. And I think that it would be important to look at that also as you are evaluating what this bill would do and potentially where it would conflict. And in that instance, what the institutions would, the position that we'd be in and what we would need to do when those conflicts do arise. As far as costs, presently, and for several years now, the community college system has not actually had in-house attorneys. We do not employ an in-house legal counsel. We rely on external counsel. So anything that we do to respond to this bill, to adopt the provisions of this bill, to the extent that we needed advice from counsel, which we certainly would, that becomes a cost right in the first instance. We've thought over the years of hiring. We have had that position in the past, but we've always stopped because of cost. Frankly, we found it more efficient to work with outside counsel who are experts in the particular areas of law where we need them. In that, this bill would require a kind of a detailed, granular look and redrawing of procedures. In many instances, we would need counsel or HR expertise to help us do that, and that would be part of the cost that we built into the fiscal note. We would also, in that this bill does invalidate or replace expiring provisions in collective bargaining agreements, we would need labor counsel to help us understand the impact on the bargaining unit and on the procedures that we have in place that have been bargained by those parties. We would anticipate costs for legal services related to attendance at hearings and preparation for hearings, insofar as they do move in a more adversarial direction. We would see costs in training personnel on these new procedures. The bill creates a set of requirements for students, student organizations, and faculty, but not staff. So that would presumably continue under present structures, which means we'd have to train individuals in the kind of a second additional requirements. We would certainly look to staff this or fund this centrally. We have 7 colleges. We try to operate through a shared services model with much of our administrative needs. We're certainly aware that colleges from time to time are criticized for increasing staff and administrators instead of instructors. And, we don't like that either. But when we need to ensure that we can incorporate new legislation that's passed, that often falls to staff. It certainly wouldn't fall to faculty. So those are some general comments. We absolutely fully support due process and fairness. We're all employees at the institution, and we want that for ourselves. We want that for our colleagues. We feel that we have it, and in the absence of voices that say that it's a problem, that there are gaps, that there's some systemic lack in our policies, and absolutely let's fix that. But I don't believe that has happened. I think this bill was brought as a in the interest of good government, and we applaud and support that. But we believe that we, as a public institution responsive to the legislature, we believe that we're delivering good government to you. We follow public employee labor laws. We follow duly bargained protections and provisions and requirements, things like timely notice and provision of information and the ability to make one's case before a neutral arbiter. Those are all part of our current provisions. And in that, I think that we are very much in sync with the intentions of this bill. I just think that in the realm of using finite resources to fulfill our mission, it's worth us all asking if this rises to the level of necessity that you would like to see as far as expending resources.
Representative Popovich.
Thank you, Mr. Chair. I have 2 very quick questions, if I may. First one is in regards to the impact of this bill, meaning that you would have to follow 2 separate sets of practices. Isn't that what already happens when you have a CBA? The CBA determines how the discipline is enforced. Wouldn't you say that currently, if I'm a regular student, I would be treated differently than a faculty member because the faculty member has a CBA that has different protections for them? Would that be fair to say?
I think that is fair to say. I think what this bill does, though, is necessitate learning learning and training and institutionalizing a new set on the faculty and student organization side. But your point is well taken.
Thank you. So to me, that's not a very, significant concern because it's a situation you're already dealing with. And frankly, the more unions you have, the more different set of rules you have for every union. I had to negotiate with, 7 different unions in town and so on. And I'm familiar with how complex it is. To me, that wouldn't be a big change. The other question I had was in regards to the Title IX conflict. Now, if you exclude the exclusionary clauses from Title IX contains exactly 37 words. And I cannot find a word there that this would be in any conflict with. I would like you to clarify if my understanding is correct, which is that the conflict is with the various interpretations of Title IX coming from various, federal organizations rather than with Title IX itself, because one is a conflict to the law, another one is a conflict to the regulation promulgated by bureaucrats who change from one, presidency to the other. And I've already suffered from a lot of whiplash, and I'm sure you do more from, when a new president comes in, the meaning of Title IX seems to change completely every 4 years.
It hasn't yet with this new administration, and our Title IX person reviewed the bill and current interpretations of Title IX within the last week, and it tells me that the bill currently conflicts.
Thank you.
Further questions? I have one for you, Shannon. On page 2 at the top, line 2, it says, in all disciplinary proceedings. Then on the previous page under definitions, there's a definition for disciplinary proceeding. And with consequences, relative to a student or member being suspended, expelled, terminated, or result in student organization being deprived of their organization on campus, etc. Are there any disciplinary proceedings that occur which do not come underneath that definition over there? Can you discipline a student for something happening in the classroom? Is that considered all proceedings? It's a very broad statement. In all disciplinary proceedings, are there any disciplinary proceedings which are not, that don't come underneath this definition?
Certainly, there are. I think that the language on page 2 that you cited would be essentially scoped by the language in the definition on page 1, if that answers part of your question. But certainly there are numerous disciplinary proceedings which would not necessarily, we wouldn't know at the outset, would not rise to this level that's in the definition on page 1. A time and attendance issue with faculty, behavioral issues with students, sure.
Yeah,
Yes.
Yeah, I just referenced when I was in public education, a student messing up in a class came down and sat on the principal's bench outside for 5 or 10 minutes or half hour or whatever you want to do, maybe all day long. And then back to the class, they weren't suspended, they weren't expelled, they weren't in school suspended, So there's different degrees, and I just don't want to capture everything over here where there should be a degree where discipline can occur. That's not going to have to take a route here where I deserve these rights. I think there's sometimes when the person in charge, the staff member, has that authority, or I don't know if that's necessarily authority, or maybe it's by policy, to address that without having to go further.
I think that's fair. I think, though, you don't always know at the outset what the end point will be. And I think that, as the previous speaker noted, we try to resolve issues informally initially, and as an educational way, helping people, within a community learn what that means. Mm-hmm. So, but again, we don't necessarily know from where something starts, where it could end in terms of discipline steps.
Further, yes, Representative Popovich?
I don't know. I I don't want to lose this thought. It's actually not a question for Mrs. Reed, but I just wanted to check at some point with the prime sponsor whether they feel that maybe clarifying the language that instead of imposition of any discipline, it would say before the beginning of any, disciplinary proceeding, that would help in maybe eliminating some of the ambiguity. I hear Shannon saying that that shouldn't be a problem. We are interpreting it this way, but maybe rather than relying on interpretation, just cleaning the language a little to make sure that not all discipline is covered. It's only the discipline as, that requires the type of disciplinary proceedings defined earlier in the bill.
I think that's a clarifying point you're making.
Yeah,
And it may, help. So any more questions for Shannon Reed? Thank you. And do you want to speak any further to anything you've heard, Representative Lynn?
Thank you, Mr. Chair. If I could just make 2 points. The first point I would make is that it's important to remember that the bill specifically contains a provision saying that student organizations or faculty members can waive any of the protections under the statute. And I think that's particularly important because to the extent that the argument is being made that we have, in many of the systems, we have a more collaborative kind of disciplinary process. I think whether the representative from UNH was saying that the faculty actually supports. Fine. There's nothing at all to prevent a faculty member from saying, fine, I like the present system much better than what is proposed in this bill, and I waive any rights I have under this bill. I'm more than happy to proceed under the more informal collaborative. There's nothing that prevents a faculty member from doing that. All this does, though, is to provide rights if the faculty member doesn't want to, proceed in that more collaborative way. The other point I would make, and I think this is really an important thing to understand, I think to some extent, and I say this respectfully, but to some extent, I would say to the other speakers, and I hope the committee will consider, you can't have it both ways. I don't think you can say on the one hand, this bill is really unnecessary because we provide all the due process protections already. And on the other hand, well, if you adopt this bill, it's going to cost a lot more money to do it. Well, wait a minute. If you are providing all of these, if you really are providing all of the due process protections, so there's no problem here, the university system and the community college system will have to do nothing. They will have to make no changes because they are already complying with what this bill would require. But the fact that they are saying, wait a minute, we're going to have to do all these other things, it seems to me that the only reason that they would have to do these other things is if their current processes don't meet these standards. And then the question that you have to ask yourself is, what of the particular standards in here do they think they should not have to meet? And I guess, I think these are sort of fundamental principles that we all recognize of what due process requires. And I would say that it would be hard to argue that the procedures in here should not have to be met. So I really do think you can't have it both ways. Either if you're really providing due process already and this bill is unnecessary, then adopting this bill will cost zero. If you're, on the other hand, if it really is going to cost you a significant amount of money to make the changes, and that suggests that what you're doing right now really isn't complying with the minimums. Thank you.
Thank you, Representative. In follow-up to where I was asking Shannon Reed, is there a level of discipline which you wouldn't go this route? For example, if you issue a letter of reprimand to a staff member, that would not be looking at here, a suspension or expulsion or terminated, or it would be a lesser degree. Somewhere along the way, there's got to be that point where this starts and stops.
I agree completely. And, you may recall that in the bill that was passed 2 years ago, as it was originally drafted, it would have applied to things less than the suspension. And there was an argument made at the time that, that goes too far, it will capture, and we took that out. So I agree with you completely. There are some, the student gets to, in your example of this, we call the student to the principal's office to sit down at outside the principal's office for the whole day. That's not covered by this. So I did not, where it says on the top of page 2, in all disciplinary proceedings, I use that as a term of art. I think that means disciplinary proceedings as defined in section 1. But if you wanted to make that, add in language to say in all disciplinary proceedings as defined in RSA 188 K21, because that's all I meant. It would have to be, if it didn't involve a disciplinary proceeding that would at least involve a minimum of a suspension, then I think this doesn't apply.
Thank you. That clarifies for me. Representative Burton.
A quick question. Thank you for taking my question. Paragraph 3, you mentioned a student can waive, or faculty can waive their rights, provided that such waiver is made knowingly, intelligently, and voluntarily. Who decides whether that person is making the decision knowingly, intelligently, and voluntarily? Could the university say, stay in court because you're not making it voluntarily? Could they say you're not making it intelligently and you don't know enough, so go with the court? Or who decides?
Sure. Well, I guess what I would say is in the first instance, it would be decided by the parties to that proceeding. But if somebody, in other words, if a faculty member says, look, I don't want to go, I'm willing not to go to the hearing process that would be required by this, I'll do some informal mediation or resolution. They would tell the school that they were going to do that, and they would proceed through that process. The way this issue would come up, I guess, would be if somebody made a claim afterwards that they coerced me into waiving my rights. I didn't really want to do it, but they told me, they in some way coerced me. The way that would come up, the way it would come up in any other proceeding where there's a disputed issue.
Thank you very much. Are there any further questions? Last question, Representative Fellows.
Thank you. I'm just wondering why, if you're so concerned that either a faculty member or a student organization or a student is not being treated fairly in this process, why did you limit this only to state-supported higher education and not apply it to all colleges and schools?
Well, I think one of the issues, the due process issue, is an issue that comes into play as a sort of constitutional issue only when there's state action. So a private institution is not, Dartmouth College is not subject to the due process clause of the Constitution when they're acting as a private institution. Now, it may be that they have some other obligations pursuant to getting federal funding or whatever, but basically this is designed to cover institutions that are subject to the due process clause of the Constitution, which only covers state action.
So it's perfectly fine if private colleges don't pay any attention to this?
Well, this wouldn't have, the short answer to that is yes, because private colleges are not covered by the due process clause. I'm not, if your question is, should they follow something like this? I would tend to say, yes, they should, but does the state have the power to compel them to do that? I'm not sure.
Representative Fellows.
I don't understand.
You're going down a path here that we have gone through in previous years quite thoroughly. And we're talking about that specific college that Representative Lind mentioned, Dartmouth College, which has their own private security And it took an act of the legislature just to get an MOU in place to share information between the college and the municipality. There are certain issues which Dartmouth says, hey, we were founded before all your statutory language was even in place. Now you're telling us how to, I think we're just, futile to try to say this is going to be applicable to every private institution in the state where they're not receiving any of our funding at all. So with that, let's close this hearing down. We will meet again as a subcommittee on this bill, and we will probably be taking action at that particular time. So I advise the caucuses on either side to get your heads together. Next time we meet, we will be making a decision on this. We're going to take a 5-minute break and then come back and deal with the last bill right now. I know some people are having to get up and so in about 5 minutes. Thank you.
We didn't know we were gonna take a break and I wasn't gonna make it for the next bill.
Well, yeah, that's just, so I am going to take a break. Okay, we're going to go ahead and start in about a minute. Yeah. Well, okay, we're going to go ahead and start right now. The next bill we have of the three bills today, this is the latter, at least this morning. HB 112, requiring students in the university and community college systems in New Hampshire to pass the United States Citizenship and Immigration Services Civics Naturalization Test. And everybody should have a copy of this. We currently do this assessment in our high schools, and this is looking to do the same at the university system and community college system. Open to discussion. Representative Popovich?
Thank you. If I may, just wanted to point out that the prime sponsor is also in the room, and
Yeah,
it may
I
be
know
a
that.
good idea to, hear his thoughts. I'm
think-
still kind of trying to make up my mind on this bill.
Well, I am doing the same, and let me give out a little bit of information that's been brought to my attention since the bill was heard. One, the university system trustees have looked at this bill, and they unanimously opposed the bill. That's all of them. Over 20 some odd trustees were at that meeting that day, and over at UNH Manchester. And that was just, I think, within the last 3 weeks or so. That's come to my attention. Also, there are several issues which have, the intent of the bill, everybody, I think, recognizes that we want our students to be civically minded and to understand their civic responsibilities. And that we ask that of our high school students who graduate. In fact, they have to pass that citizenship test. And in many places, it's now been integrated into their history classes or their classes which they have taught at the high school level. The issue which has been brought up by the university trustees is that a number of their students come in from foreign countries, a number of students come in from other states where there's other requirements that for the social studies areas. They're also, the other primary concern they have is that going down and mandating something from a state level on procedures and actions at the university system seem to be getting down in the realm of the responsibility of the trustees who had the responsibility for those policies, ensuring that they follow the laws and the regulations, rules of the state. In terms of, it could be the start of going down and saying, we're going to do this, this, and this, and this. And so that is a concern. And of course, then there's also the management and supervision issues associated with this. How do you ensure? So with those things put on the table, perhaps we ought to have the prime sponsor come on up and try to, address some of the concerns of where we are.
Well, thank you, Mr. Chair. Good to see you all again. Yes, be happy to speak, very happy to speak to what you just brought up and any other specific questions on this measure.
Okay, one of the questions would be the demographic in our state, the population's really shrinking in terms of K through 12. We're down to roughly around 155,000 students versus where we were going back to 2008, 9, 10, about 210,000 students. So our reservoir of students is not increasing, it's declining, and we're having to then chase more students that, unfortunately, they're coming from out of state. And so our enrollment sizes are upwards towards 60% out-of-state students, 40% in-state students now. It's another hurdle for them to jump over to get into one of our systems if we have this assessment. Can you speak to
Sure.
that, please?
Thank you, Mr. Chair. I've heard that before, and I disagree with it very much so. And I also want to say I would have loved to have had a chance to speak to the trustees when this came up at their meeting so that some of the aspects of this measure, which we already passed a couple terms ago, could be developed. There's a lot of misinformation out there. To your point, I have to reject that thinking, the notion that we shouldn't expect people to know stuff because they might not want to come here. I utterly reject that. In fact, I think it's a plus. I think parents, if they knew that there was a little expectation here of actually knowing a little bit about how government works, would be a plus in terms of parents or in some cases students wanting to go someplace where there are some standards and expectations about how our country works. So I completely disagree with that premise, and I think it's wrong-headed thinking.
Okay, Representative Popovich.
Thank you. Just a quick question. In reading the bill, it refers to graduation, but it doesn't seem to define graduation from what. And I'm trying to understand when I'm a CCSNH student taking a couple of technical classes, would this apply to me or not? How do we determine which subset of the students would this affect?
Sure. It should be fairly clear, because we've talked about this before in terms of who would need to take the test, either at CCSNH or USNH, and it would not apply to people in certificate programs. It would be simply for degree programs. So whatever the associate or bachelor degree program, doesn't cover a master's, whatever degree program a student is in, the expectation would be that they would pass this assessment before they would be allowed to graduate. I do want to circle back to something the chair brought up in his opening statements about foreign students. When we passed this a couple terms ago, I was in favor of foreign students taking this. We compromised on that, and we said foreign students don't have to pass this assessment. As a compromise. So that's already been addressed. We addressed that before. Personally, I think that if a foreign student is here, they should learn about how the country works that they're going to school in. But that, we already took that out. And I also want to point out that many other states have this requirement in place. I could go on and on. They've done the due diligence. They've passed it to South Dakota, Missouri, Florida, on and on and on. And beyond that, beyond the public university expectations that other states have put into place, many colleges have their own separate assessments. Sometimes they use the USCIS exam as a graduation requirement. Purdue University is an example that I've cited. They have a specific test along these lines that every graduate of Purdue needs to take, so that when people hire a Purdue person or whatever, they know that this person has had to satisfy certain basic citizenship knowledge expectations, and it's very popular. Again, I wish I could have spoken to the trustees, because I will say, anecdotally, parents love this. The high school version has been a huge success, I think, anecdotal responses. And this is intended to cover some gaps. Again, in the community college system. By the way, I spent 20 years in the community college system, and I spent 12 years in the university system. So this is, I know the cultures, I know those systems. And to give a exam or a required exam like this, it should not cost $1 million like the fiscal note says. It shouldn't even be a fiscal note. We didn't have a fiscal note the last time we passed this. Registrar offices have robust operations to sanction credit by examination. They do this all the time. So the fiscal note mentioned having to hire a person at Keene, a person at Plymouth, a person at Durham at $130,000 a year to give this test. And having given countless online examinations myself and with the Moodle system, a university system, or used to be Blackboard and now Canvas, I put countless assessments online, and the students would take them when they took them. And if they passed them, they were good. So I see virtually no financial component. I think, and I know these systems, I just addressed that. So it troubles me that some folks, especially in funding committee, maybe don't have the post-secondary experience. I know Representative Burton does, could get snowed over this $1 million figure that should not be there. So anyway, thank you for letting me get those points in.
You're welcome. Further questions, Representative Burton?
I hope you give me a little latitude, Mr. Chairman, because I'd like to make a point. I happen to know Representative Moffett, that you're a distinguished military officer, and I think a lieutenant colonel. And the principle that we're trying to reach here is, how do we get students to be civically minded? And my experience in the military was, we lead by example. You can pass out all the documents you want, but if you're not leading by example, then you're not going to reach the students. In court 3 weeks ago, the judge looked at the state and said they could identify no authority that would permit the Department of Education to terminate funding or otherwise sanction K-12 school for failing to submit a certification of no DEI by September 5th. Direct contravention to federal law, the judge said, was shocked. Shouldn't we be, by our behavior, be influencing my grandchildren who live with me and ask me about this? Why are you giving me all this high-minded stuff when the state is going to cut off the schools?
Representative Burton, I'm not going to give you any more latitude on that, seeing that we're not dealing with DEI in this bill at all. And
Mr. Chairman, I'm dealing with citizenship, is what he is
then
promoting.
you just mentioned DEI, however, and it's. I understand your concerns of dealing with civics and trying to have civic-minded individuals in our society. I get that, but I don't want to have any references to topics which we're not dealing with. Thank you.
So I guess I will not respond to what I heard. Is it, or?
Well, let me give a question then and I'll take myself as an individual that I went to Vietnam. I enlisted, became an officer while I was serving in the service, came out, then went back to University of Maine. If University of Maine had this test required, isn't my civics-minded responsibilities and the way I work, wasn't that demonstrated by what I did in joining the service and serving my country and taking a sworn oath as I enlisted, put my hand up and said, I will. And so are there, I'm looking now, for example, like the community college system, which has a lot of adults that are beyond that of the 18-year-old kid coming in from high school, who have been in various activities, such as the military, or maybe years ago, like something like the Peace Corps, or some other activity which is serving the best interests of our society, and living up to those ideals spelt out in our Constitution. So why are those individuals who have demonstrated, rather than showing it on some kind of a written test, which they're demonstrating it by doing, by putting everything on the line? That's where I'm coming from right now.
Thank you for that, Mr. Chair. And this type of thinking and perspective has come up before. And I agree. I hear what you're saying in terms of life experience counting for something. I absolutely believe and support that. And some provisions are in place in some institutions to grant college credit for life experience as a process for that. So I hear what you're saying, and I get that. However, there is civic actions and civic knowledge. Now, there are some folks who say civic actions, civics is about civic actions, being civically involved, taking up a cause, climate change or free Palestine, whatever. And that is a place. But the tools that people need, whether they were in Vietnam or whether they did whatever, we owe it to not just high school students, but especially to post-secondary students who are going to be having college degrees, that they have some minimal knowledge of how our government works. Senator D'Alessandro is somebody I go back 50 years with Lou. He recruited me to play basketball back in 1973. And Lou, as you know, Senator D'Alessandro, the senator from Manchester, was a huge civics proponent. But again, he was not keen on assessment, the assessment part of it. And I think that the assessment part is crucial. And what I listened, this passed this House already, and then the Senate re-referred it, and they get hung up with some of the misinformation that you got and that they got, and they finally passed it. But I listened to the debate in the Senate, and I so wanted to say to Senator D'Alessandro, Coach, are you going to send people out on the football field or the basketball court to play when they don't have the fundamentals? And I think he would have gotten that. I couldn't ask that question because it was a Senate executive session, but hopefully you're getting my point. Civic actions matter, and also knowledge matters, and assessments matters. I know some folks are averse to assessments, but they're important. I believe in them. I use them all the time. We have a driver's test for a reason. We have a bar exam for a reason. I know people at the community colleges, and the people who take x-rays have to pass a registry. They have to pass a test. Now, we could, I guess, to take that logic further, we could just let people have driver's licenses without giving them tests. So I am in the camp that believes in accountability, in assessments, and in knowledge. And basically, and I know you voted for this last time, Mr. Chair, eventually this is going to come down to, is very simple, knowledge, and having a very low bar of common knowledge that people need to demonstrate, or ignorance. Right now, I spent 32 years in post-secondary in the two different systems. I will tell you that people, most students don't, as you have said in the past, have a hot clue about material they should know about if they're going to be, good citizens. So there's that. I know it's kind of a long answer, but yes, I hear what you're saying about civic engagement, and I think it needs to be augmented by assessment.
Further questions from the Representative Bricky?
So, thank you. So I heard Representative Moffett now say on a number of occasions that he believes that there needs to be a minimum knowledge of how government works. Civics is already in the curriculum that students need in order to graduate from high school. Although if last year's bill had passed, it wouldn't, but thank God that didn't happen. I have an issue with his disparaging the fiscal note and the people who came up with the fiscal note. And I believe that the people who came up with the fiscal note knew what they were doing. They were experts in what they were doing. And to say that there would be no cost seems erroneous to me. And I would agree with the people who know about what the fiscal responsibility would be, as opposed to Representative Moffett telling me that he doesn't agree with it.
Thank you for that. And I will have to tell you that I did get with the OLS folks when they saw the FN, because as I said, the previous exact version of this did not have any FN at all. And they said, well, they asked post-secondary people, experts, what it would cost. And they largely deferred to post-secondary. Shannon and I have had a couple of very candid conversations about this. Yes, I do disparage the fiscal note, absolutely. And you can, again, as I've said, the fact is that every college has a robust registrar's office who routinely gives credit by examination. Now, the costs for this would be, I would happily input the questions onto Canvas so that it's there. And so all the registrars need to do is put a group or class together, and whoever has not taken the exam would take it online. So I absolutely think this FN is ludicrous, frankly. I'm very honest. There shouldn't even be an FN. I think this shouldn't even be in this committee. That's my opinion.
Representative Popovich.
Thank you, Mr. Chair. Without issuing an opinion on this particular fiscal note, because I didn't really have the opportunity to study it properly, I will say that in my third year on the Finance Committee, there have been fiscal notes that were reasonably accurate, and there were fiscal notes where we really had to question the assumptions used in building them. So I think a healthy discussion about the fiscal note is a perfectly reasonable thing to do in education funding. We may disagree with it, we express why, and everybody has an opportunity to say that. But please remember that every forecast, and the fiscal note is a forecast, is a best guess of what may happen in the future, heavily depends on the assumptions made at the time. And whether those assumptions were reasonable or not, sometimes only time will tell, or we'll learn new things and we realize an assumption wasn't correct. So I would never take a discussion of a fiscal note to be a, disparaging type thing. I think we healthily need to debate it because we're talking about the forecast and best guesses, and we can maybe differ in opinions. So I really appreciate hearing different points of view, and it's our job to figure out which of them we lean towards. So.
Thank you, Representative. I do not believe that we need to hire someone at $130,000 a year on 3 campuses to administer this assessment, which can be given online, again, at minimal cost. If I may, to one more point that the chair raised at the beginning, he talked about the kind of the trustees being concerned about this setting kind of a precedent, and this has come up before, and I think that the precedent I would be concerned about would be the precedent that the people and people's representatives can be blocked by a prevailing sentiment on the Board of Trustees or by this committee. If most people believe in something that they think that a public university should have as policy, that matters. And for the precedent I would be concerned about would not be having this modest assessment, which many other states do. My concern about a precedent would be, okay, so the trustees have veto power over the people. They have veto power over the legislature. If they don't like something, the bureaucrats or the people who are on these boards, then they can say, we can't influence aspects of post-secondary education to include learning. Again, this comes down to knowledge versus ignorance. So I have to take a little bit of issue with what the chair said at the beginning in terms of this setting a precedent. I see it the opposite way.
Representative Damon.
Thank you, Mr. Chair. So first of all, in response to what Representative Moffat just said, I frankly take offense to any suggestion that any of us at this table are being bought by university trustees or anyone else we get information from. We are not being bought. Thank you. And then to what I intended to be saying prior to that remark, I fully agree with the need for there to be an adequate knowledge of how government operates and of civics. What I don't agree with is that this in any way accomplishes that. there are a number of questions on this exam that I simply don't think contribute to anyone being an informed, capable citizen and hopefully voter. For instance, what territory did the US buy from France in 1803? Really? I don't think that influences you being a good citizen today. And two more examples. Name one of the two longest rivers in the US. That's geography, not civics. And how many amendments does the Constitution have? It doesn't matter how many there are. It matters what the Constitution says. And there's many more examples that I won't cite. I just do not think that passing this bill accomplishes the purpose that is stated as the intent. I think it's.
Thank you, Representative. In response, I'd say I certainly don't think I said and didn't mean to say anybody here is bought. That's not what I said. It's not what I meant. But my point there was that we should not give up our, as legislators of the representative people, I don't think that we should defer to unelected folks who aren't in tune with what maybe the people want. The assessment is 120 questions, and I've read them all. And they all can be tied in to government history. The three examples you gave, I don't want to take up too much time, but I love this stuff. I taught this stuff. And in terms of rivers, what do rivers have to do with government? Well, a lot. Mississippi River, Ohio River were boundaries between states that had different laws, between different, the Spanish and the French owned New Orleans. And so knowing about rivers or the other points that you made, they definitely could be tied in. I think this body of knowledge, 128 questions, how many amendments are there? Yeah, sure. Does anybody know what an amendment is? Again, I would call it a crisis of knowledge that most college graduates don't know how government works. And this has come up before. In fact, people say to us, to you and us, well, why don't you take this test? And I don't disagree with that. I know several terms ago there was a sexual harassment requirement in the House. And to have if this online test is out there, to have rules, have us take it at some point, that's okay with me too. So anyway, thank you for your comments, and I would love to talk about rivers and that type of thing with anyone later on.
Representative Fellows, and then I want to get back to the committee, or the subcommittee work. Go ahead.
Yes, so that test you're talking about is 128 questions, which are published. Anybody can study them. And they have nothing to do with civics. They, as you said, they have to do with history, nothing at all to do with civics. There's no question in there that asks anybody, explain the three branches of government or what they are and how they interact. Nothing about that. That's what civics is about. It's not about, the rivers, and it's not about when we had a certain battle at what time. It's about how the government operates. So if we're going to give them a test that's about, if you want to know if they want civics, we should have a test that's about civics. But for any student that's gone to high school, public high school, that's public, I'll stick with that, public high school. They've taken a civics course, so I hope they know a little bit about that. But this test is ridiculous, to waste time and money giving a test where the 180 questions are known, and it doesn't even have anything to do with civics.
Thank you, Representative. It's 128 questions, not 180. It used to be 100 and it was 128. And I have to absolutely disagree and take issue. It is all about civics. There are some history type questions and a couple of geography questions thrown in there that do relate, as I just mentioned before, to implementing laws. And you're just mistaken when you say that there's no civics in the civics assessment. Again, look at the 128 questions. You said it doesn't say anything about the branches of government. It does. There are questions in there about tripartite government. So I just have to take issue with how you look at the civics test when you say it doesn't have civics.
Representative Bricky.
So, thank you very much. I understand Representative Moffat's passion for his subject of history. I was a lifetime educator of mathematics. Do I believe that some of the students should have more mathematics knowledge when they graduate? Yes, I do. Do I believe that a test would help them? No, I do not. I believe that this is not needed, and when we vote for it, I do not see myself voting in the affirmative. Thank you.
Thank you very much. The question which I brought up initially, one of those, dealt with the issuance of this test to all students. I'm still not convinced why we're going to judge how effective a carpenter is because they took a test. I'm more interested in knowing what kind of cabinetry that person can make. I'm also concerned that we have looked at education in terms of what you can do, and how we teach it is there's a number of ways of doing that. And if a person has been in the military and served his or her country and done so many other things, maybe in other ways they've served and helped this country, or sat on their local select board, or dealt as a city councilman or alderman, those count. And to make them jump this hoop, especially at a time when we are challenged to find enough students, the university system is really hurting in terms of new students coming in. We're going through that demographic, and we funded them at $87 million this year and $77 million the next year. And yet our tuition costs are not going down, they're going up. And so now we're going to put another hurdle in there. Really, realistically, I think if we put many more hurdles in there, people are going to opt to go to UMass Lowell or Amherst or Orono. Some other school where they don't have to jump these hurdles. So there's a number of issues which I have to be convinced of right now, that this is going to lead to more students or less students, or it's going to make our students more civic-minded when they're already adults coming in and are civic-minded. And I fully understand the rationale between K through 12 and requiring our high school students to do this. And we know that all our high school graduates now have this. But we don't know whether they have it from Idaho or from California or from Florida or from Kentucky. And quite truthfully, I'm more interested in having them come to our college.
Thank you, Mr. Chair. We kind of touched on this earlier. So it sounds like you disagree with all the states that help put this in. You disagree with Purdue University. But I get to your point, which we touched on earlier about life experience. I've already acknowledged and agree with that matters. But I don't think you need both. I think that for example, you mentioned a carpenter or an electrician. Just let them be a carpenter or an electrician or whatever. Well, I think that apprenticeships matter. Hands-on matters. That's important. It may be most important. But I would want an electrician to be tested and certified to know that they have been reviewed by people before they start, putting electricity into my house. So, in a hurdle, again, I disagree with that. Representative Bricky was a educator, and Representative Burton as well. If something's presented as a hurdle, as you put it, or a chore by the people giving it, then the students are not going to get a good vibe from that. If something's presented as an opportunity, if it's presented as a challenge, that's good teaching, that's good leadership. And if the students understand that this is something that people want, there's no downside to this. You have ignorance or you have knowledge, for knowledge. And the notion that it's a hurdle or an expensive $1 million thing, I just fundamentally disagree with. And again, I've touched on some of this already. I don't want to repeat it for a third time, but the notion that classes are fine, I will tell you they are not. I've been in the trenches. I've been in college classrooms for many years, and I know that the lack of knowledge on basic government. Now, do they take civics in high school? Yes, some civics classes are great, but they're all different. Some teachers emphasize activism or whatever, and not the fundamentals. And so when every high school class is different, then to have a unifying, consistent, solid, fundamental, common base of knowledge, that's what parents want. I am telling you. That's why the high school version has been so popular and is so successful. It's one of the best things we've ever done, I think. And so why have it in college? Well, for most community college students, it won't matter. They've already taken it. 93% come from in-state, but there are older students who come in. So why should an older student not be part of that common knowledge foundation group? Why should they have a waiver and not have to know what other students know? Now, the university system is different. Half are from out of state. Some may have taken the test or not. Again, people would, the value to the university system, I would tell the trustees, had I been at that meeting and able to speak to this enhances the degree. This enhances the value of a university degree. It doesn't hurt. It only helps. It enhances. It improves support for university system, community college system. When parents know, okay, anybody who graduates from either of these systems is going to have a hot clue. They're going to have a solid, common knowledge foundation in how our government works. People want that. It's all the questions, as has been pointed out, are out there. My niece just graduated from Concord High School. She came to America as a fourth grader and didn't speak English. She got 126 out of 128, and she said, and others have said that, the students initially don't want to take it. Those who have taken it recommend everybody behind them takes it because they learn stuff. And this is, I know it's education funding, but so much of what we do in our education committees has next to nothing to do with learning, pedagogy, or knowledge. This does. We passed it before. It went to the governor, and I'll take just a minute because the governor did veto it. As a matter of respect for me and the sponsors, Governor Sununu and his staff, when this got to his desk, he said, I want to talk about it. So we scheduled a meeting, had to reschedule. Scheduled another meeting, had to reschedule. Finally, and then Representative Lang came with me. We met with the governor. We went through all the issues that he brought up, that you brought up here, and we left there thinking, okay, he's going to sign it. And he didn't. And I found out later that the enrollment period had ran out earlier that day. We'd had to reschedule the meeting so many times that he had to make a decision and he vetoed it. So what he did, and I think this is very important, he tweeted out a photo of him and me and then Representative Lang, tweeted it out on social media, thanking us for coming in. And I think that was his way of saying, sorry, if we could have met a day earlier, I'd have signed it. So, but that's my opinion. But so, yes, we passed it before. You voted for it, Mr. Chair, and passed the Senate, went to the governor. I think if we pass it again, which I hope we do, only good things will happen. Thank you for giving me that minute.
Representative Brown?
Thank you so much. So the key to mastering any subject matter is repetition and review. And although the K-12s do offer the civics test, this is another way to reemphasize those lessons. So asking students to demonstrate minimal knowledge of our country seems like a no-brainer to me. Honestly, I do appreciate this bill very much. Even those who are interested in upending some of our founding institutions should at least know the status quo. So I do appreciate this bill very much. I also was teaching Canvas this morning at 4 a.m. grading exams, and $200,000 to $1 million cost estimate is just grossly overestimating the cost of this particular issue of this bill. It's ridiculous. I had to laugh. But honestly, I truly appreciate this bill, and I cannot see many arguments against it. So I appreciate it.
Thank you so much, Representative. And your point about repetition leading to retention is so valid for as educators know. And this reinforces the information, and that's the value. And again, I go back to Coach D'Alessandro, which I wish, as I already said, I wish I could have said to him, fundamentals matter. And to be a good football player, Lou, coach, you need the fundamentals, and you need to go over them, and then you retain them, rather than just going out to play football or going out to an activist gathering. So thank you for that, Representative. I really appreciate it.
Are there any further questions from the committee? Representative Burton?
No more DEI, I promise, Mr. Chairman.
Thank you. And I'd like to really wrap this up.
I do, me too.
We have another
Me
one
too.
coming up.
Yeah, you brought up Vietnam, not me. I got the Civic Actions Award from the South Vietnamese government for going into a village we just decimated and paying installation payments to the people who survived. I had a book that showed how much a wife was worth, a child was worth, an arm was worth. And when I came back, and you've read my book, so you know my story, how do we teach civic obligations that you can protest policies you don't like? On television last night, I saw a woman thrown to the ground who was protesting in a city. And it's tearing our country apart, because I do feel that civic education means being able to question what's going on. It stopped the Vietnam War, let's face it. How do we get that across to people that you have a right to protest things that you find unjust or need to be changed?
Thank you for that, and thank you for your service. The test is not a be-all or end-all, it's a tool. But to your point, the activists or the people like us, we're all here because we care about public policy. The people who care deeply about whatever their issue is, they should know about the Fifth Amendment. They should know about the First Amendment. They should know about the Fourth Amendment and the Sixth Amendment, and actually all the amendments. So to your point, I think that the people like you and others who have their issues they care deeply about, to translate energy into effective activism, they need to know what the process is. And if there's been a lot of stuff, First Amendment recently, you know, in all these amendments, 14th Amendment. So the activists, people who want to make a difference, they need to be effective activists, they need to understand the processes and some of the history and the precedents of how government works, and so that they don't waste their time going down some rabbit hole that would be unconstitutional. So if you're tracking me, yes, I hear what you say, and I think activism and knowledge should complement each other. And we have a lot of activists who don't know how the heck laws are made, then that worries me. That's why I think measures like this could make a difference.
Thank you. Any further questions from the committee? Thank you very much for coming today.
Thank you. Thank you all.
Welcome. Are there any further comments? No? Okay, so we will be, with the other bills in higher education, talking about that. We'll also have a caucus prior to then. We won't do it now, but we will do that, and I hope the other side does it as well. So with that, are there any more questions from committee members, subcommittee members? No? So this meeting is adjourned. Thank you very much.
Yeah, 37, please, who needs 40?
Okay, I think we're ready to go ahead with the next building, meeting we have today, and that's for the school building aid bills. And we have two of them, HB 295 and HB 366. This will be a second meeting of the Building Aid Subcommittee. For a reminder, the folks which we have on the subcommittee are way over on my right-hand side, we have Representative Peoples. And then coming in, Representative Popovich Mueller is going to be taking the position of Jim Kofal today. Representative Dan McGuire, myself, and to my left, we have the members on this particular committee are Representative Luno, Damon, and Fellows. And we have Representative Bricky, who is taking the spot of Representative Luno. Luno is not able to attend. There's some family issues going on right now out of state, and which are going to take a lot of his time here in the next several weeks or more. So I'd like to have Representative Damon and Representative Fellows, and then Representative Bricky. We have these two bills, which I mentioned earlier, and I'd like to look at one bill first. That's 295. This is the Making School Building Aid Program Funds Non-Lapsing, which was a bill which was suggested by the Department of Education. And it has, if you have a copy of it, is the basic change is right on the bottom of that on lines 5, 6, and 7. Funds appropriated pursuant to this section shall be non-lapsing. We didn't have a lot of funds allocated in this one. Yeah, really. So, yeah, unfortunately, that's where we are with the building aid program right now. We're paying our debt, but that's about it. Let's have some discussion. It was submitted in conjunction with what had come from our previous, I think it was before you, Tim. Came from Amy, I believe.
Yeah.
Yeah, I think that was the genesis. I'd spoken with her many times too, and evidently Representative Cahill captured that and put it into legislation here. So let's have an open discussion on that briefly here. Anybody have any thoughts or feelings about making this fund? If you allocate X number of dollars, it will become a non-lapsing dollar if it's not used. Representative McGuire.
So let me just ask, is there like a timing problem where, you know who should get the money, but their application isn't quite ready or something, and therefore they go beyond the date, and that's why you want it to be non-lapsing, or is there some other reason?
No, I don't believe so. So we can encumber them funds once we have commitment from a district, so that locks up the funding past the lapse date. And so I don't think that's it. I think part of the issue was, we have projects that don't accept a partial funding for a project, that I think the preference would be to have it roll forward to the next biennium and add to that amount of money that's now available for school building aid that are currently on a list.
Oh, I see. So like you allocate 50 and all the projects add up to 47, but the
Correct.
next project is 10 or something.
Yeah,
right?
and again, depending on the list and the cost of those individual projects, it could be significant.
Sure.
We could have $12 million that nobody's willing to take at that time. And so do we lapse that, or does that roll forward? That I think is probably
We
the
had
reason.
considered about 50% of what you said when we put all this legislation together years ago with then the Commissioner of Education over in Maine. And where you go through all your applications that you have money for, you might have $1.5 million left over, with the next one being the $10 million. And they say, no, I don't want it. So then you go down the list. Maybe nobody wants that. They want to stay on the list and grab a full amount in the following biennium. And so that's what this does. It just keeps it there in that pot and would go towards the next biennium or next round, whatever that might be. That's what it's all about. Now, I'm going to go and deal with the committee members here. Representative Damon.
Thank you. Thank you for helping us with this. Is there any mechanism in the circumstance that you've just described where there is some money that could be awarded, but it's not enough for the full remaining project, that a district could say yes to, say in your example, $1.5 million for a $10 million project, and invest that money during the year while they then would be perhaps top on the list for funding, for the rest of the funding the next year. Is there any mechanism for that?
No, I'm not aware of anything like that in either legislation or rule.
Representative Popovich.
If I may, I think the problem in that mechanism that you're asking about is the partial award to a district and then still keeping them on the list, which would be very tough to work on. If you would give the money to a district, of course, they have the ability to save it and invest it longer term, they put it in capital. But I cannot think on how we would do it from the administrative side where we give them money but keep them on the list for the rest of it. It would kind of guarantee that they are next, and then we would kind of throw doubt on the next term's reseeding of the list and all that. So that's kind of what my reaction is to what you're saying. I see where you're trying to get to, but I'm not sure if we have a good way of.
Yes.
Thank you, and thank you for your concerns. But I don't see it in the same way as being complicated. If they were the next approved project on the list in a given year, so if we had enough building aid money, they would have gotten their, say, 10 million, for purposes of example. If they've received part of it, why, I don't understand why it would be complicated for them to be first on the list for the next year since they didn't receive all their funding. That's just how I see it.
Ricky.
So I have a question. So if a district gets takes partial payment, do they get off the list? Is that
Yes.
what happens?
Yes, it is.
Yes.
Okay.
And you don't take that to invest it either. You take it to use it for that capital project. Yes.
Of course, but the idea was to invest it until you get the rest of the money so you can actually get
So
going,
it would
right?
still be useful.
But the concern that would be brought to that would be that as a legislature, I don't think it's a really good idea to try to tell the next legislature what to do. And the same thing in the construction projects, right? If we sorted this here and this is the list, a new project that wasn't on the list could very well be deemed more worthy of the money. So we would, in a sense, be pre-making those decisions. And that's where the complicated issues are for me. The mechanics are simple, right? But it's just what's the right thing to do.
So let's get back to Representative Peoples.
Thank you. Thank you so much for taking my question. My question basically revolves around the distribution of this money. Would the town already have to have an approved project that was voted on by the local voters? So there's no projects that run without some state and local funds. So would they need an approved project?
No, so what the current rules require is approval or commitment by the school board. And they do not have to have a bond vote completed in order to be on the intent to fund.
Thank you.
Yeah, the projects, there's certain dates there, and by January 15th is when the notification has to be made to the school districts on their applications, I believe, if my memory serves me right. Yeah. And at that point in time, you don't have any town meeting occurring at that point in time. This is the old schedule.
Correct, and it's actually 32 months
Yeah.
that they have to, so they get, basically towns would get 2 shots at it at their school meeting to approve the vote. So that money is actually locked up for 32 months and it can't be offered to the next school on the list until they go through that or just return it basically by saying they're not moving forward.
Representative Peoples.
So if we made this non-lapsing, how would it impact that rule?
Well, again, we encumber the funding, and so once it's encumbered, it's therefore, as I understand it, locked up past the lapse date because it's been committed to a project. And then after they decide not to move forward, then it would be available for lapse, but it wouldn't necessarily be at the year end.
Representative Popovich.
Just to further address my colleague's question, the difference would be if we encumber it, if we non-lapse it. then it would not be returned to the general fund as unspent and be subject to the new budget process. So basically, by making it non-lapsing, we would be telling the next legislature, no, you don't get this money, it stays in that fund, which also, very bluntly, doesn't mean that much because the Finance Committee can change rules as needed. So it would not have as much of an impact as we'd like. It would be more of a, this is the intent of the legislator, that in general, this is the process. So I really don't consider this to be a very impactful piece of legislation, but it's still good to determine its merits and see if this is a better way than the current way. So.
Okay, looking at the subcommittee right now. Yes. Oh, I didn't see it.
I just wanted to point out to everybody, it's raining outside.
Can we get up and do the happy dance? In case you might have left your windows down.
Oh, yeah, you run out to the car and do it now.
Yeah. Do it quick.
Okay, any other important topics there, Representative Fellows?
The only thing I can say is Representative Cahill talked to, I think, the accounting people, and they recommended just changing the last sentence to, instead of saying funds appropriated, change it to say state operating budget appropriations for school building aid shall be non-lapsing. Just a technical thing to make sure that they get the right accounts.
Can you read that again?
State operating budget appropriations for school building aid grants shall be non-lapsing.
Okay. Any more discussion on this bill? Because we have Representative Cahill.
Thank you very much, Mr. Chairman. The reason Amy Clark gave to me for this request was that because sometimes we have some very small projects, and $1 million here, $1 million there could add up to be enough to satisfy one of those very small projects. That was her intent. So if we have it, otherwise we give it back to the general fund. It may not come back to the building aid, but there you have it, where some small project could get done rather than waiting for infinity.
See, I'm having a hard time understanding this because, yes, I agree. We can have some small renovation projects, which are only like 25% of the cost of building new. And I think that even at that, it's going to be more money than $1 million. You know, I can't believe that, 25%, that means the whole project would be what, $4 million. Not necessarily but it's a small project, but anything less than that, I guess right now with consolidation issues being a real issue in school districts, to go from 3 to 2 buildings, but in order to do that, you got to do renovation in that where you're going to consolidate all your students to one of those other schools. That's where I'd like to see some monies available to help with that consolidation project, but it doesn't mesh with our definition of renovation project or new construction project right now. It's lesser money. You see where I'm coming from a little bit? Where the consolidation may only require $500,000 or $1 million. And even if they matched it, that'd be only $2 million. But that's enough for some of these consolidation projects to get that chemistry lab built or to get the extra classroom built onto. It's like in Bridgewater, they just built on 2 classrooms there attached, of which all the plumbing and everything to that was already in the ground when they built the first village school. So building the 2 classrooms, it's just brick and mortar basically, and maybe some water.
Well, again, I think, these smaller projects would be on the list, the ranked list. And as you go down, the other part that often happens is the school board may have a project and have it tentatively approved, and then it falls short in the warrant article. And then you have all those funds that were encumbered. Do they go all back to the general fund, or could they go to the next project? I think that's how Barnstead got done.
or the groundbreaking happened. And that same logic you could follow through to the $8 million project wouldn't take $4 million, but I bet the $5 million project would. No harm in doing it.
Representative Popovich.
Thank you, Mr. Chair. I don't know if the question is for Representative Cahill or for the department, but I'm trying to understand what happens if somebody gets approved, gets on the list, right? They have 32 months to take care of this. And the first time they go to the ballot, say that they get one of those spectacular Wyndham specialty 33% to 67% approvals. And they throw their hands out and say, okay, this is not going to happen. Take me off the list because I'm out. In that situation, given that we are still technically in that term, would the DOE have any flexibility to go to the next department on the list? Or would this be, it was first allocated and not? As I said, I didn't know which way I was aiming, so I just shot in a general direction.
I think I know the answer, but
Yeah,
I think we prefer to have it come from the department.
so if it's still within that first biennium, then my understanding it goes to the next school. So we do have the intent to fund, but then every May 1st, we do require the schools to send us notification if they want to stay on that list. And so again, this time we only had 4 that opted to stay on the list. But if money frees up, we would just go to the next one on the list and send them an intent to fund letter and see if they want to move forward and work our way down the list. Barnstead was mentioned; they were number 10 on the list, and they were able to end up getting funding because of I believe the size of their project was small enough that the projects ahead of them were too large and did not want a partial award. And so it went through the system down to number 10. And then that is when Barnstead accepted that. And that being said, we still had $769,000 left over. But nobody below 10 wanted to accept that as a partial payment.
$769,000. So is that the money we're talking about as non-lapsing?
Yep, this year.
So
That's correct.
That's what we would non-lapse,
Correct.
because nobody wants it. Or they all probably want it, but they can't take it.
Yeah, correct. And if you add it to the next biennium, it's more funding available to maybe create another project that would be able to accept it or not. Again, the 769 is just the current number. There's nothing to say that could not be perhaps 12 million someday or 5 million, so there is a potential range for that to be larger.
So here we are with this bill. Any gut feelings on this one? It's not really one of those high priority ones that put your hand, go either way on it, but Representative McGuire?
So in general, I'm in agreement with Representative Popovich-Muller. I'm a long-term member of the Finance Committee, and I strongly dislike automatic spending and dedicated funds and things like that. I'm the chair of the Dedicated Funds Committee, but anyway, because it ties the hands of the Finance Committee when we have to come up with a budget. And he's right in the sense that we can always say, notwithstanding RSA 1, 2, 3, 4, spend the money this way, right? But the thing is, there's a kind of an out of sight, out of mind aspect to this, where if you don't know that they're sitting on $3 million for this project, for available sort of, it doesn't always kind of come to our attention, then we say, okay, it looks like you're going to need 20 or something, when really 17 would have done it, right? And so, that's my point. I just, in general, don't like non-lapsing and dedicated funds and automatic spending in law rather than spending based on the current circumstances, because that's what the Finance Committee is charged with doing. It's making decisions based on what's going on right now as to where the needs are. And sometimes it's in HHS, and sometimes it's here, and sometimes it's there. So that's what we have to do. So I'm against it, but he's right. This is a very minor bill. I mean, it's not going to kill anybody if it goes one way or the other, as far as I'm concerned.
Yes. Representative Fellows?
So I agree with Representative McGuire in terms of really not liking dedicated funds when they, but in my case, that's my opinion related to state agencies and some of the projects in the state agencies. I think what's different about this is if we could make this non-lapsing, what would a possible scenario is that once every 3 years, we've accumulated enough of that so that we're funding one extra project. I mean, that's what you keep that extra money and you're going to build on that and you will end up, funding more projects over the span of a couple of years than if you don't make it non-lapsing.
So what's the Finance Committee going to do when they know that we have in that non-lapsing fund $1 million and we can fund up to $50 million according to statute? We're going to fund $49 million.
48.
Or whatever. Representative Bricky.
I believe that the amount of money needed is still $20 million, whether you have $1 million or $2 million over here. As Representative Fellows said, just because you have that money over there, they still need $20 million to fund the projects that are needed. They probably need all 50 million and then some. But I disagree that the Finance Committee should look at what is in some non-lapsing fund and then say, okay, we were going to give them 20 million, but they have 3 million there, so we'll only give them 17. I don't believe that that's a sound way to do the budgeting, but that's my opinion.
Justin Damon, and then Representative Popovich.
Thank you. I think it needs to be acknowledged that we are not allocating or appropriating anywhere near the amount of building aid funds that are needed by school districts. And I'd like to ask our, sorry, I can't recall your name, I apologize.
Tim.
Tim, thank you. To perhaps give us just the broad strokes of what didn't get funded this year for school building aid.
So this year we have 7. We had 4 that returned and 3 new applications. The largest one being Concord, which is now number 1. I can give you the numbers maybe from, let me give you numbers from Concord. For example, the new number 1, original estimated building aid, 48 million. And then Litchfield, I believe is still on the list at 7 million. Barnstead, which is under construction, and that's already funded, but that was about 13 million. Monroe, that was to be determined. The original project cost is 2.2 million and 30% rate for that. So probably 700,000. Sorry. Kearsarge Regional High School is the number 4. Again, 24 million original project cost, 32% is the building aid rate on that. We don't have the final numbers for the new ones, the 3 that are currently being ranked. Once we're done that process, we'll have those numbers. But just ballpark, I would say 80 million
total for the 3.
On those 3. One's a new school for Littleton. One's a major renovation at Woodsville. And then Wyndham is a smaller renovation. But again, that 80 million is kind of a guesstimate, if you will. I don't have those numbers in front of me.
Mr. Chairman, follow-up.
Is that the project cost or is that a state cost?
So I tried to define when I was explaining it, which ones are project costs, because we don't have state cost on some of these projects calculated. It's indicated as to be determined. And that's based on various caps that are in the new rules.
Well, for example, on Monroe, you were talking about
2.2 million project
2
cost.
million, and then
What's
you were
the project cost?
Project cost, yeah.
Yeah, and then the rate was 30%, and you're talking then $661,000.
Right.
Correct,
He
yeah, I think I said
700.
700,000,
He
yeah.
said 700, yeah.
Okay, so we have 7 on the list right now?
Correct. We have 4 that were on the original 17 that wanted to come back and stay on the list. And then we have 3 new ones that we're in the process of ranking right now.
Okay,
And you said, oops, sorry.
go ahead.
And you said you thought that those 3 would be about 80 million?
Yeah, again,
So
I
would
don't
that
have
be
a good
projects?
handle on that
Right.
number.
Would that be project cost or state cost?
No, I believe that would be closer to state cost.
So the total is 143.4 million.
Okay, yep.
Mr. Chair.
And some of those estimates are back in 2022, when those figures were developed.
Correct.
Yeah, representing.
So then just to complete that circle, thank you, Mr. Chair. How much was allocated this year? And then from that, you've told us that there would be, I've now lost the number of how much would non-lapse if we did this.
700.
So from the prior biennium, 769,000 lapsed. There's obviously 0 for these projects we just described. 0 was put into the biennium.
And
Go ahead.
how much did we say? How much did we actually put in the budget for building aid? What was
What was
26 or 27?
Yeah, what was the appropriation? I forget.
It's basically paying our debt.
That's right. Okay, so there were no new projects, right?
Correct.
Okay. I couldn't quite remember that.
Representative Cahill.
Thank you, Mr. Chair. And I think we all heard Mr. Carney say one of the projects is around 700,000, which is the amount that was swept. And if we'd had this non-lapsing, the project would be going forward. I also heard him mention Litchfield, and I remembered seeing your former colleague on this committee on education, Mr. Bohm, who expressed some disdain that Litchfield again had turned down the warrant article for the school. And I know he's not one to spend money, but sometimes you have to do it. It's just, we just need to get progress here. This is a little bit of progress. We need a lot more progress. I'll leave it at there.
So what we need to do is get back on whether we're going to lapse or not lapse, and Representative Peoples.
Yes, thank you. I'm from the Litchfield District as a representative now, so I can tell you that the voters resoundingly turned down the warrant article. It was not by a small amount, it was by a large amount. The building aid, if it had been a larger amount, may have helped offset that, but the reality is that the taxpayer just didn't want to absorb that. So I don't know what you do when you're in that case. Right now, they're looking at re-envisioning that whole process, but I'm not sure the non-lapsing funds would have helped us.
I understand the situation, because Newmarket, we turned down a few bond articles before the moratorium, and then it was kind of late. So I understand what you're saying, but a little bit is better than nothing, and nothing is what we've had for an awful long time. And I do wish the people of Litchfield do get a little bit more support so they can do what they need to do with the school.
Okay, so we're on the issue whether we should, go up or down on this particular bill. I don't think we're talking big money in this thing. So I don't, I would advise both of the caucuses to come back at the next time we meet with an understanding where you're going to go on this thing. Okay. We'll do the same thing. So the heartache on this whole thing is the next project on the list is $176 million cost. And what they need, if they get their 40%, is they need $70 million. We don't appropriate much more than 50.
Right. I thought he said 48.
These are the figures I'm dealing with.
Concord?
Yeah.
Yeah, Concord.
If $176.7 million is what that estimated project cost, and that's what I got back in 2022, the 40%, they would get 70.5 for,
So Tim, didn't you say 48?
Yeah, there's some caps on the square footage. So building aid has a cap on allowable square footage. Concord could be larger than that, and then the taxpayers would pick that up. So that's why there's a discrepancy on that.
and that's a good point to mention, though. A lot of times these costs that are projected are not going to be what the project's netted out at the end.
Correct. That's why you'll see some of those are to be determined,
Yeah,
just because those caps haven't been applied quite yet.
thank you.
Mr. Chair, but in no case are these projects getting cheaper. So I think if we continue to kick the can, it just gets to be a bigger can and a longer road. And I know you're with me on doing something. I appreciate your.
I certainly am, but eventually, if our demographic goes the way it's going, we won't have any students to put in these buildings.
Oh, we'll still have some.
Okay, we're going to go on to the next bill right now. All adjusting aside here. 366, relative school building aid for eligible projects. Here we have a bill that's going back to pay buildings which have already been built and not gone through the process. And we've been just looking at another list of those that are applying, which it's, it's just, what we're appropriating, what we have, it's very difficult. The ones which are applying are buildings which really have still need, whereas the ones which have been paid for by their locals, that need is gone, but they may be needing some money because they're in the hawk for it. So that's where we go on this one. It's I think we need to be looking at the whole process of school building aid here. And that's what I'd like to delegate a little bit of our time before we get into discussing this one, how we're going to go on it. I'm very concerned, as I always have been, on what we're appropriating for new construction and renovation. But there's different ways of looking at this. There's one camp out there saying we shouldn't be doing it as a state. That's a local issue. Totally. There's another camp saying maybe what we ought to do is allocate a certain amount out to each school district based upon a formula of some kind each year. And that goes into some fund which grows. It can be managed by the state treasurer, or it can, with the interest, that would have to be determined whether it goes back into that or if it's used for emergency projects. There's a lot there. There's other issues which we're looking at right now where should we have a smaller amount, let's say, of the $50 million we appropriate for small projects like consolidation projects or those renovation projects, which don't come up to the 25% level, but there's some projects which they need help on, which are still very costly. Should we have a smaller amount there? One state, Maine, does have deals with lease, renovation, and construction a little differently for each. And then we have, other camps which are saying fund what we got according to the present formula, but fund it appropriately. Or, we've had bills come in that say, okay, we will fund up to 50 million and the other one no less than 50 million, including or excluding the debt. So you appropriate your debt plus the $50 million or whatever it may be. So I'd like to have a little conversation on that. I did have one model here, which is basically very similar to what Senator Lang had done years ago. I want to show how one of these models might work. It might give us a little bit of a discussion. Let's see. Let's just go that way. I'll keep this one right here.
Okay.
This is a model which deals with handing the money out annually. And this is, the Lang model went strictly on per pupil. This model right here, and if we go left to right from A through I, I'll walk us through this. A is whether you're an LEA or state. So this hypothetically would be the state. ADMR, how many kids are elementary, middle school? How many kids are high school? And so for state with 151,990, it's been broken down. You can see it breaks down with the numbers, which we had 104,000 and 47,000. Then the next column C there is, do we appropriate dollars, the same dollar for elementary, middle, and high school? This one is, it even cuts a corner. It has elementary, middle school at the same amount, which is not necessarily so if you look at some construction manuals. So this one has at the elementary, middle school level at $149 per foot, and at the high school, see, the high school amount was also $194 per square foot. And you can see what that adds up to for those students, $24,766,000. Construction cost, the average cost per square foot is $235 per square foot. These are not accurate figures because they cost more than that, or they're the whole figures. You would see the total square footage cost at $5,820,000,000. Additional costs for any project, you have to add in some things such as equipment allocation, so that's 10% added on top. Architect fees, that's a 7% add. 20-year debt, if you're going to incur that, retirement, that would be a 6%. So this 23% additional cost would be added to that cost, and your total cost comes out to $7.1 billion. If you add on that on top of the 5.8. Column F, percentages premised upon a flat rate plus annual debt, $50 million. So you can see on that particular column, the FY26 debt would be, or available would be 20%, then it increases from 27 to 22%, and FY28, 24%. These numbers have all changed, but these are just some things which might be looked at. The state share would be E times F, and then you have H, the annual state grant allocation would be, G divided by 50-year life cycle. And you can see that, and it comes out to what would be allocated out for the state. It's another approach to looking at how we fund education for Building 8. There's a lot of issues, a lot of negatives, and some pluses to this. And this is just one way, but it's just a quick synopsis, but it's not where we want to be in terms of everything you need to take into account, but it's something to consider. The other issue that I am concerned about is the consolidation of our buildings right now. Efficiency of scale, we have buildings which are operating at some high costs because we are not filling them up. And could we consolidate? We need to be consolidating or merging on the district levels, but even internally within the district, there's room for consolidation. And we've put that as one of the criteria for awarding points. Consolidation, saving property taxes, and making things more efficient is one of the criteria which we presently have. So is there possibly we can develop a formula which deals with consolidation? I'm just going to open it up to discussion right now. Then I have a possible LSR which could address that type. Maybe I ought to hand this out first. Representative McGuire.
Oh,
I thought you had
him.
Yeah, let's see if you got enough going down that way. How many you got there? You need one more?
I think we need one left.
What this LSR may do, it's just been submitted as a placeholder on top of anything else if we do anything with Building 8. There's, yeah, Okay.
Is this just the words to go with the spreadsheet?
No. This is totally different.
Oh, okay.
Okay, if you look down line 16, effective July 1, 2027, we're talking next biennium, school building aid grant funds pursuant to RSA 19815A4, Roman 4, that's just right above this, shall include construction and renovation funding support for school building consolidation projects. Consolidation is the word. The purpose of the school consolidation building grant award is to achieve 1, long-term school district savings, 2, efficient use of district resources, 3, cutting operational, instructional, and administrative costs, and 4, expanded educational opportunities by sharing staff, facilities, and access to curricular and co-curricular programs. As part of the school building aid program, an eligible consolidation project grant award shall be 50% of the department-approved project costs, provided that no public school consolidation grant award shall exceed $1.5 million in any fiscal year. The rest of it deals with the 10-year plan and saying it's no longer may, it shall, you shall complete it. But that would be a way of trying to address some of the small consolidation projects, and that money would come out of the $50 million that's appropriated for school construction building aid. That's another way of doing it. But as a subcommittee, we should be trying to look at where we need to go with building aid. It's open to discussion. Representative McGuire.
Thank you. So I'll just give you a initial reaction to these two proposals. So the first one, the spreadsheet one, I really like this. I think it's much superior to what we have now. What we have now is got many problems. First of all, there's a lot of administrative work that goes into it, right? People have to spend a lot of money applying. We have to have people to read those applications, and we have experts to examine them and all this sort of stuff. And I see that as kind of wasted. Whereas this is just sending money to districts and let them handle their own building as needed, when needed. If they want to renovate, if they want to build new, all that sort of thing, that's up to them. We don't have to get involved. So it certainly would have a lot less administrative overhead. And I think there's a fairness sort of thing here, because certainly everybody has buildings, and everybody's buildings wear out, and so this is across the board giving money to everyone. Whereas the system we have now, it's more like the lottery, right? Everybody buys a ticket, but somebody wins and everybody else loses, right? And it's unattractive in that way. So I really like this, whether the details that we can talk about later. Now, the second one I'm not so thrilled with, because this to me is, you're saying that these districts, or maybe it's multiple districts getting together, are going to save money by consolidating, and therefore we should give them money to consolidate. So I don't see why, if they're going to save money, they have plenty of incentive to do it on their own. Why should we pay for it? It's similar to these programs we have that pay Walmart to put in LED lights, right? They're going to save money on their electric bill, so why should everybody else pay them in order for them to save money? Why so this one doesn't make as much sense to me.
Further discussion? Yeah, Representative Ricky.
So I see a flaw here in that we never talk about more than $50 million. And it's obviously not enough. It hasn't been enough for building aid in years. So the fact that we're still saying, oh, we'll keep it at $50 million, I don't think that that's a good way to go. But I mean, if we could talk about the funding, sure. I think I need more time to look at this, although, again, it still caps building aid at $50 million. But this does say less any debt service, which is actually a plus in my feeling on it. So that's it.
Any further discussion? Representative Peoples and Representative Damon?
Thank you. Using Litchfield as a good example, we've tried to get a new school now for, I think, 25 years. It's been a long, arduous process. The town has voted it down every time. But during that time, the school board stopped doing maintenance. Matter of fact, Ed Murdo from the Department of Education, I was at the meeting when he said, I'm not giving you $1 for that school for renovation, not one. And the school board took that as the marching mantra that they were never going to repair this school. They stopped doing maintenance on it. They did the very minimal they needed to do to keep the building open. So now we are here with failed bond issue after failed warrant after failed warrant, and we're to the point now where we have to do some renovations on the schools. As we look at these formulas, we need to take into account for districts that have done those kind of things, deferred maintenance, so that doesn't fall on the body of the state. We need to wrap the process around an easy way to do it. I tend to like your first one here with the spreadsheet for that, because then they're solely responsible for how they spend their money. There's no local control issues. The only thing I see as a downside to that is that we're going to get the same thing that we get with adequacy aid, is that it's not enough. We need more. We've spent more. We need more. But that's my 10 cents.
Representative Damon?
Thank you. So I have some thoughts and some questions. And I think I'll start, if I may, Representative Peoples. Not sure I'm fully understanding the Litchfield explanation. So if you could help me. The district decided, and it sounds like the state also decided, not to fund maintenance. Is that correct, first of all?
The state does not fund maintenance.
Right.
We
But I thought you
always
referenced
put maintenance in the budget, but the school board doesn't always get the maintenance done. So we have a shortfall and we need a teacher over there. So they take the maintenance money, they move it there. The reality is they didn't make maintenance their priority on this building because they kept thinking they were going to get a new building. And the problem with that is, unless that's assured, you need to continue to do your maintenance. You wouldn't stop changing the oil in your car because you're going to buy a car in 2 years. You need to do, huh?
I understand that. I just
The exclusion for Representative McGuire with that particular issue. But so they've come to the town, multiple school boards have come to the town with multiple proposals. Our last one, and don't hold me to the figure, I think when they figured out with the bond costs and everything else, it was going to be about $62 or $63 million after we paid for the school. In an elementary school with declining enrollment, we're 130 or 140 students less than we were at that school alone. I sit in the school building committee, so I do have a little bit of insight into that. They're working on right now trying to come up with a proposal that the town will buy. Matter of fact, there's a meeting next week to re-envision the school. But they left us maintenance. And I just feel like when a district is negligent in maintaining the buildings that we've helped pay for as the state overall, the state has an interest in this, so we have an interest in the student. We've paid for these buildings. And then the town, through maybe no fault of their own, doesn't maintain them, or lack of funding. We just can't reward that bad behavior, and whatever the funding formula is, whatever we get to, we just can't reward that. We need to make the process simpler. I think the school building aid application process is crazy, and come up with a way of giving districts an easy way to approach getting the funds. we should give them a little bonus if they want to renovate rather than build new. I think it's the other way around. They get a little more money if they build new rather than renovate. Consolidation in our district, right now, the real thing that makes sense is to consolidate on the two schools. And restructure our two schools, which would have some renovation costs attached. Where that all goes, the voters will decide, but if we could find a way at the state level to make the process fair, equitable, and easy to accomplish and still fund it with enough money, I think we'd be really doing something.
Tim, a question for you. The money which we appropriate in school building aid is basically used for new construction and renovation projects.
Correct.
There's a definition of what renovation project is.
In rule, yeah.
In rule.
Yes.
In rule,
Yep.
not in statute. I understand that.
Yep.
So a consolidation project may be considerably less than a renovation project in trying to prep an older building that's half full, half empty, to bring some other students into it, to maybe now you're going to extend it from K through 6, it might be K through 8. So you're going to have to prep it for the middle school kids, and they're going to make it in middle school. If that consolidation work is less than that qualifies them to be a renovation project, where do they go to seek that money? Are they able to do it through school building aid?
No, I don't believe so, because it is, I think it's major renovation is 25% of what it would be to build a new construction, yeah.
So that's the idea about the consolidation being also, eligible within the school building aid program. And you might recognize some gain, not the first or second year, but it's going to be your efficiency of scale is going to certainly change a little bit when you don't have to have your personnel going between 3 buildings. Now they're going between 2 buildings. Administrative costs will change. Custodial costs will change. And there's a lot of other non-labor type issues which will increase some change too. Insurance, all that. Utilities. So consolidation is something we should be moving towards and trying to incentivize school districts to move in this direction. In fact, it is one of the criteria we have for awarding grants out right now. Representative Damon.
Thank you, Mr. Chair. So I would just share that currently there is an elementary school consolidation happening in Claremont that had been discussed over the last, I think, since at least 2019. The city has gone from 5 elementary schools a number of years ago in 2 different consolidation processes to 3. And now looking at going from 3 to 2, I shouldn't say looking at, it was voted to go forward with it last week. They are doing this on a very fast track because of lack of staffing, particularly in regards to special education in the elementary school with the least enrollment. They are projecting a savings, and the finances are not the primary reason that the consolidation is being pushed at this point. But they're projecting a savings of $60,000 to $70,000 a year, which is not an insignificant sum of money, but it's not very much relative to what I think people would have expected it to be. There isn't, in this particular consolidation case, a savings on staffing. All the staff are moving with all the students and trying to maintain integrity of classes and educators, in part because of doing it a few weeks into a new school year. I mean, it's not ideal. I think pretty much everyone agrees the timing is unfortunate, to put it mildly. So I just share that for some perspective on one situation. And I would also note that in that project, in a couple of other much less progressed consolidation discussions, I think it's really important that we not overlook the expense of transportation. So in the Claremont case, there's going to be an increase in transportation costs because most of the students in the elementary school that's closing walk to school. And they will no longer be able to do that, to go to the two schools that they're being dispersed to. It's too far. So that is a piece of the puzzle that we all should be paying attention to. Not only the cost of it, but the reality that school bus drivers are hard to come by. And so how they're going to make that happen remains unclear, and kind of urgently needed to be figured out. And I would think if we are looking at one part of a new model of building aid funding being targeted to consolidation, that whatever rubric is used to review those costs, if we're reviewing them on a state level, needs to include some transportation perspective. And then separately from that, and then I'll step back. I'm very concerned about how do we do this to respect the different capacities of municipalities across the state when we have such disparate property tax rates and such differences in the valuations. Quite simply, there's a lot of variation in what districts are able to afford to do, and that greatly influences what building age projects pass or don't pass locally, and it influences what options are available to students. And I'm not sure that either of these proposals addresses that aspect of things adequately yet.
Representative Bricky and then Representative Popovich.
In respect to consolidation, I think it needs to be noted that not all school districts can consolidate. So my school district is a multi-town school district. And in the charter for our school district, it says that each town will have their own elementary school. So Salisbury and Webster, they both have very tiny elementary schools with tiny amounts of students, but we cannot consolidate them because there needs to be, according to our charter, an elementary school in Salisbury and an elementary school in Webster. So I think that we need to think in terms of, when we talk about consolidation, know that I'm sure that we aren't the only district that has that. So we need to think in terms of, we can't always just push consolidation.
Representative Popovich.
Thank you, Mr. Chair. I was curious, listening to Representative Damon talk about the different levels of ability for towns to fund education and building and so on and so forth. Obviously, currently the formula does have an adjustment for that, right? You get a certain amount of reimbursement going from 30 to 60. Would a mechanism to that work in general terms, obviously without talking numbers, or are you thinking about other ways? How would you get that, done? Would the existing mechanism work fine? Do you want to suggest changes to that? I'm just trying to better understand what your thoughts are on that.
Yep.
Thank you for the question. I do not think the existing mechanism works fine, although it's better than not having any differentiation between resources to communities. We simply don't fund building aid adequately altogether, so it's hard for any mechanism to work ideally when most of the projects go unfunded year after year. I don't know that I would say in this moment that I have a perfect, never mind a perfect solution, I don't know that I have a proposed solution. Open to discussion.
The reality to the whole situation is, though, each year comes time to funding school building aid, and the only one in the room, probably in the general court, is going to say, I love this, is my school, it's the next one on the list. and everybody else is out there saying, why spend $50 million? I'll never see it. So that's a real issue. But the other issue we're dealing with, and it's a reality factor, we're funding education on a per pupil basis. You lose students, you lose dollars. Simple. It's a simple equation. We had 210,000 kids back in 2010, 11, 12, somewhere in there. Now 150-something thousand kids. we must have space available in these buildings. If we housed them at one point in time, and it was higher than 210,000 kids at one point in time. And so, yes, buildings get old. I understand lighting and all that other stuff needs replacement, but we have brick and mortar structures, which are, we must have a number of buildings out there with which we can close down or consolidate. This is not, I'm not talking merger. Merger is when you're talking about SAUs combining and you get on a larger grand scale. When you're talking about consolidation within the district, there's going to be issues. For example, you're right, there's agreements that have been made and you will have an elementary school. Well, how old is that agreement? Made back in 1964, 1970? And it's time to
67.
yeah, in that era. And so it's time to say those agreements have to be reviewed every 10 years or so and start over from scratch. Town of Carroll would love that, where they're having to pay the freight for that whole district up there because they've got a lot of wealth in terms of land, but very, very few students. And so, and they've been in court appealing that 3 different times and lost every one of them because they're outvoted on the darn district structure. So we've got to recognize we are really coming down to a very hard corner to get by. How do we deal with this? A shrinking demographic. We're not funding building aid. And when we do, it's only hitting 1 or 2 districts at max. We got to do something. Or else we can slam it right back on Ray's district and say, Ray, it's up to you to do it.
For the entire state.
Yeah.
Dan?
Mr. Chair?
Yeah.
I'm pretty sure I'm not that intelligent. But I guess you can sum up the whole thing in a quick sentence. You can't keep doing the same thing and expect different results. We need to do something different.
Yeah. And then after you, Representative Fellows? Go ahead.
Oh, I'm sorry.
Dan.
So Representative Damon's story about the Claremont shows that this is consolidation is happening at the local level, right? They went from 5 to 4 to 3 to 2 schools, right? So all on their own because circumstances forced their hand, right? So it's
all on their own, the first 2.
well, whatever. I mean, the process happened for whatever reasons, but the point is, it's not incumbent upon the state to micromanage the local situation. Is my point. And so in this particular case, I mean, what makes sense is happening, I guess. And I would agree with you about the this charter stuff. Obviously, you need to ask the voters to make an amendment, right? Because again, with the current situation, no longer makes sense.
Representative Fellows?
Yes, so just looking at the handout that you put together and when you add a value, the plan is, their plan should identify construction, renovation, and building consolidation expenditures. So a building consolidation is not going to cost much unless it involves construction or renovation. Although if you're going to take all the kids from one school and put them in another, you have to figure out what you're going to do with the empty building that you left behind, which if you need to tear it down because you can't use it for anything else, that's going to cost you some money too. So I'm just wondering if in general, when we talk about building aid and when we evaluate building aid projects, we should be looking at the cost savings that's involved in it. Because one of the things I think Representative and Ladd and I are dealing with and has to do with the Grafton County building is that sometimes renovation could cost more than tearing it down and building a new one. And when you build a new one or you renovate, are you actually going to save any money short term and long term? You need to look at both of those factors. Maybe we should, have some something in place that helps districts understand that better, and so the state can also understand it in terms of what you approve and don't approve for projects with the money that we don't even have to spend on this topic.
We're all tapped out. Representative McGuire.
Thank you. Well, presumably, if you have an extra building, you can offer it for sale, right? And there might be somebody who finds a value there, right? I don't know if anybody's ever been to Portland, Oregon, but there's a hotel called the Kennedy School, which was a former elementary school that a company turned into a hotel, and it's got restaurants and when your room that you sleep in looks like a classroom. It's got blackboards and it's got, whatever. It's kind of cute, but so there's things people can do with stuff. So,
Representative Popovich.
Well, while we are still off the rails, I would like to point out that you don't need to go to Portland, Oregon, because you can go to Boston and stay in a luxury hotel being built in a former prison. I would strongly recommend the visit because it's kind of educational, but this being said, I will be quiet because I don't have anything to add to the building aid for now.
Yeah, the whole conversation was started because we need to take a path which is going to, either correct some of these situations which we're encountering right now, or else make one that's going to be helping us with some of these efficiencies of scale. And if we're operating buildings which are half full or half empty, that's real costly. And if we're going to consolidate, maybe we can save some dollars. There is a lot of research out there regarding merging and consolidation, and you can save dollars in some situations, mostly on your local level. Trying to consolidate a broad span of buildings, eventually there's some savings, yes, but it takes a while to get there. So I think we need to be looking at this. I'm kind of really hesitant in saying we need to keep on with the same model we have. But to get to a model where you're out handing out every year X number of dollars to a district to put in some kind of an account, it's going to take 20, 30, 40 years before they have enough to really build that building. So there's issues there. Of course, it comes down to how much you're going to put in the 50 million or 100 million. And where's that coming from? So we have some challenges ahead of us, and I would encourage everybody to be thinking, maybe are there some options when we're not thinking about? And Tim, also, do you have any information on all our school districts in terms what their deferred maintenance costs are?
No, the department doesn't collect that
Doesn't
data.
collect that.
No.
Because, yeah, we have districts which, like the one I'm in, they've deferred. Now nothing's working. The roof is leaking, HVAC is crummy, no heat in the wintertime in the main multipurpose room. The sewage system's not working underneath the building properly. And we've tried to move everybody into the middle school and make a K through 8 type facility. And it's costly. And so here we are still struggling with, as a lot of districts are, we're struggling.
Rep. Fellows was before me, but if I could.
Which one's first? Representative Fellows?
Yeah, I'm just wondering, Tim, if you have anything that tells us how old the buildings are, because I'm sure there are schools out there that are over 50 years old, full of asbestos, have heating systems that can't be easily replaced and will cost, it's starting to look like, it's not worth it to replace it. If we know where those schools are, because if they are, whether or not they're currently on the list for asking for building aid, that those are the critical situations that we should be looking at and seeing what we need to do about that.
So in answer to your question, I did see Amy had done a survey a number of years ago. The data escapes me at the moment, but it was a self-reporting. I know there's been discussion, I think the last meeting of this subcommittee, a discussion about the facility, statewide facility study. But we don't have what I would consider a comprehensive set of data points for schools in the areas that you asked about.
I can give you those data right now. 50% of school buildings in New Hampshire are over 60 years old. 50%. 6% were built prior to 1900. 26% built prior to 1950. 7 schools are over 68 years old, have not had a major renovation in more than 50 years.
What was that last percent?
The last 26% built prior to 1950.
What's that report called so we can?
This is data that Amy Clark and I put together years ago. I just happen to have this right here. It's testimony I've given back on HB 365 back in 2023. And the last one, 7 schools are over 68 years old that have not had a major renovation in more than 50 years. 15% of schools are using portable classrooms. 5% are using 4 or more portables. And it goes on and on and on. Yeah, I can get that. That was testimony we gave way back in 2023. I'm sure it's not changed a heck of a lot, seeing we don't know.
It's just gotten older.
It's just getting older.
Buildings are getting older.
Yeah. And here's an interesting quote I'll read you. Listen to this quote. The success of our whole system depends as much on a thorough reform in the construction and care of schoolhouses as upon any other single circumstance whatever. When do you think that was written?
1800s.
From the report of the Commissioner of Common Schools in New Hampshire, June 1847.
Do I get a blue ribbon?
You get a blue ribbon. Yeah. Yeah. And then Representative Damon, then Representative Popovich.
So, Mr. Carney, could you weigh in, what would it take for the Department of Education to provide a report that evaluates what, like a broad picture of what would be needed for these aging schools? That's a very general.
Yes, no, and it's a proper question, obviously, but so again, I understand, and I haven't, I've talked to Representative Ladd about the statewide school assessment that was proposed perhaps 3 years ago.
Yeah, well, it went back to,
Was it earlier than that?
went back to Mark Joyce even prior. That's going back a ways.
Yeah,
Dr.
okay.
Joyce.
So if you want comprehensive information, that is what would need to be done. I would not have the capacity to do that. And I did speak with, as a follow-up to some questions from the last hearing, I did speak with a company that does that Amy Clark had reached out to several years ago to talk about this. And I did provide Representative Ladd some numbers on a per square foot basis. But it really comes down to what is the exact scope, what information would the subcommittee or legislature need moving forward, as that would really drive the pricing on something like that.
Representative Popovich.
Thank you, Mr. Chair. My comment is both about the assessment of the, current state of the buildings, and because it relates to that, the amount of deferred maintenance. I would like to caution everybody against trying to obtain that data by polling the school districts. Because with all due respect, when a school district is in trouble, they are the people who kind of made the trouble happen, and they are highly unlikely to tell us that they created an issue. People have incentives to report data that furthers the purposes of their organization, and honestly, the only way in which I would be comfortable using such data is if it would be gathered by a reasonably impartial organization that uses a single standard to evaluate. Otherwise, I'm going to have to consolidate 200 reports from 200 different organizations, each of which has their own definition of deferred maintenance. It's going to be worthless. So whatever data we get, I would strongly suggest that we gather it in a uniform, consistent way across the state, ideally using whatever organization we may select that's reasonably consistent and objective. Because otherwise, you're just going to encourage games of politics in terms of under and over reporting like you've never seen before. So
We went through that and we agree with you, or the legislature did then, that it has to be done through a contracted service. It has to be done with people that are aware, an engineer, architect, these type of people that go out and rank these schools based on the same criteria. The 33 million square feet that we have, and now if we were given three figures, 5 cents per square foot, 10 cents, 15. We're probably up 15, 20 cents per square foot now. And then, you know, if it's 10 cents and 33 million, we're talking $3.3 million. So you're really talking that a commitment. But then the next thing is, what are we going to do with the information we get? That's the question. Because, you know, you're going to find out you have all these situations which need correction. Then you're going to really have to do something. Representative Popovich, yes.
Very briefly, though, I don't know if I can tell you right now what I would do until I actually see the data. I mean, we all think we have an idea of what the overall picture is, but we don't really know that. And it's very hard to speculate now that if I get this result, I'll do that. If I get this result, I'll do that. I think the healthy approach is to recognize that we don't even have the clear underlying data that's usable, and gather that data and use that to inform further, you know, legislatures and debates. But right now, you know, I don't see much of a point in speculating what I will do if the survey comes this way. There are 1,000 scenarios. So.
Anything else for today? Representative Cahill.
Thank you very much, Mr. Chair. And to the most recent point, I would agree. I think the idea of having a team of experts go to every school would not only give us an idea of what actually needs to be done, it would help with prioritizing the need. And I know you've been trying to do this for years, and the question of spending $3 million, it's probably well worth that investment and more. As far as the handouts, if you were to, I agree that consolidation is going to be, you know, district by district. We're all different. One size fits all doesn't work. And if you were to append this to my bill and do everything else I asked, I'm fine with that. You know, consolidation is a worthy way to get something done, accomplish something, improve the school. You know, we should make them be eligible for building aid, but just put the $60 million plus and start to give something back to those districts like Claremont, like Newmarket, like Windham, that invested the money in their education and are still waiting. You know, their property taxpayers are burdened. Now to this formula. I have a few major objections. One, you're giving money, as you mentioned, it would take a long time for that money to rise to the amount where you could do anything with it. But you're also giving money to districts that had recently updated their schools, or they've always had the resources to do it, and they've done it without any difficulty. And I think our current system, with all its flaws, does provide something. It provides a different percentage of grant depending on the fiscal capacity of the district. It does that, so we're not telling the poorest communities, no, you can't ever get this. We're trying to make it a little bit easier. The problem is that even in those districts where you're giving them 60%, the cost, everything else, the cost of education, because the state doesn't fund it, that goes all on the property taxes. I can understand why it's so difficult to get 60%. This is something else I tried to fix. A simple majority will get things done a little bit easier, but 60% is a pretty high bar to reach. And I know in the case of Claremont, it was one vote shy. So everybody should vote. Every vote counts. But I think this is what the formula here doesn't really solve the problem, and it has a number of flaws that I think just don't get it done. And I think we need to tweak the other system. Back in 2015, I suggested that we return to the annual funding where you pay down the bond gradually rather than the 80-20. I know the 80-20 has its advantages, and I don't know if it's possible to let the district decide which way they'd like to do it. I mean, I mentioned this once and people said I was crazy, that won't work. But, outside the box, maybe there's a place that says, yeah, just pay us over 20 years and we're fine. And someone else will say, give us 80, give us 60%, and then we can get it done, however it has to work. There maybe has to be some more flexibility. I also was concerned about giving people the money and let them wait until they had the money. We don't have the department, the engineers evaluating the project. We could end up like something that's not really well done. You remember a school that the contractor said they could do it cheaper. And we do want to have a clerk of the works, but I think we also have to have some oversight, the square foot, the kind of things that the district needs. This comes under the team of experts that you'd like to impanel to go school by school and evaluate them. So I think I think I'm a no on this, on the formula, and an enthusiastic yes on this if it pended to HB 366.
The last thing I'll say here today, and then Dan, on that potential idea of the consolidation, there is a section on the backside which is law already, but see, what we have is the Department of Education shall develop and maintain a 10-year school facilities plan of potential school building grant projects. 10-year plan. Right now, the law says each district is encouraged to review and update the district's plan. This changes it to shall, and they shall every 2 years, and of course, every 2 years they're supposed to be doing this, so that when we come to appropriating monies down the road in future years, we have an idea of it's like your 10-year transportation plan.
Just wrote that.
And the whole concept here was to have the 10-year plan for schoolhouses, but also joining this was the need for that survey. And we got this part in the law. It's encouraged. This bill changes that each district shall review and update. It's no longer an optional thing, in which I think they should be doing. But
For 2025.
yeah.
For
So
2026.
Representative McGuire.
Yeah. So I wanted to say the main thing that I agreed with and Representative Cahill is that not every district's the same. So I'm a big fan of a fiscal capacity aid section of the formula. There's a big difference between what Newcastle can do and what Claremont can do, right? I mean, they're just very different places. One has a lot of property value, the other has very little. And so I think it should be the business of the state to balance things out a little bit, right? And not, not waste our money giving it to Newcastle and instead give a little extra to Claremont, that kind of thing. So I agree that just the per head aspect of it, that could be different. So.
Do I understand then that we should not be carrying coals to Newcastle?
Yeah.
The fiscal capacity disparity aid is something we've been discussing, and we only put $13.4 million in the budget for it this year.
That can change.
That can change, and it does need to change. Just take it out of the extraordinary needs grant and swap it over. Okay, so is there any more discussion for this one today? No. Okay, I advise everybody to do their caucus work, come to the next one when we have it, and we're going to make some decisions then.
And scheduling?
Yeah, do you want to try to do some scheduling for this one right now where everybody's head is here? So obviously we're looking at October. What do you got going on, Dan?
Thursdays, I generally have stuff. So.
Okay.
But that's about it.
I'm trying to think where I have the. Anything during that week of the 13th through the 17th of October?
Only that the 13th is Columbus Day.
Oh, that's right, that's right.
3 weeks from now, you're saying?
Well, for this aspect of it.
14th or the 15th.
So let's go to another week then, because this Thursday 16th's out too.
Merrimack County has a county.
Yeah, we
I would
have,
really prefer to meet the week of the 13th. I'm gone the last 2 weeks of October, and Dave is not certain.
We're talking about the building aid committee, right?
This subcommittee,
This
yes.
committee right here,
Yeah,
right?
yeah.
I can meet any day that week. Is there any day that works
Well,
for people?
It says the 13th is Columbus Day.
That's Columbus
That's not
Day.
a state holiday.
best for me would be 14th or 15th.
I'm
I
good with
can't
either
do
of
it. I have
those.
a doctor's appointment and I have something else.
Good for me.
14th's good for me.
Is the week before too soon?
I can't do the 14th.
What about the week of the 6th?
I could do it in the afternoon.
On the 6th, I mean, in the sun on
Afternoon
Pawleys
is fine.
Island.
Nice. I love Pawleys Island.
That's where my daughter
You
lives.
can do afternoon of the 14th?
Afternoon of the 14th.
Sure.
That works.
Yeah. I
1
can do
o'clock?
that.
1 o'clock on the 14th. Do we have a date?
Yep.
Yeah.
Awesome.
Good. Okay,
Thank you.
that shall be it. Maybe we can put something else on the morning of it for some other committee or it's,
We have 3 more, I'm sure we'll find something.
Yeah, really.
yeah, I know it. Okay, 14.
Still so- when I'm texting, it's still on.
I have an idea of paper this.
Say again.
Jen, can you get that date to Karen for the calendar, the 14th at 1 o'clock in the afternoon? Thank you. Anything else for the docket? Go to the order? No? We're adjourned.
Thank you.
Thank you much.
Thank you.
Thanks for coming, Tim.